Yeah. Chess and the Timmons. Yo. I'm the man in charge, triple dip justice, my reach is large, indicting T-Rex arms, yeah they on display, short reach, big mess on a public way, yo. Adjust your antennas, tune in tight, Posse rules the bench, I'm the law tonight. Be so high, they touch the sky, the joke ain't over, just watch me fly. Adjust your antennas, tune in tight, Posse rules the bench, I'm the law tonight. Be so high, they touch the sky, the joke ain't over, just watch me fly, yeah. Advanced years, wisdom stacked, try me once, no turning back. James Jackson ordered, case dismissed. Kasi cheek strikes, you won't resist. Yo, yo. Order in the court, the rhythm pounds. Justice echoes, breaking bounds. Prosecutor by day, mic in hand by night. Adjust your antennas, I'm the signal, alright. Antennas, tune in tight. Kasi rules the bench, I'm the law tonight. Be so high, they touch the sky. The joke ain't over, just watch me fly. Yeah, adjust your antennas, tune in tight. Kasi rules the bench.
This is all he wants to do. He will stare at me. He will jump up on me when I least expect it. He just wants to sleep on my lap. That's it. He knows I'm talking about him right now. Look at his ears. He knows it. Hey, boy. Brando. Hey. Can you wake up, dude? Oh my God. How do you say no to this? Look at him. He wants to go back to sleep. That's it. That's all he wants to do. Brando? Oh my God. You are too cute for words, dude. All right, go back to sleep.
Basically as damning as you get, dude. And I haven't even gone over it yet. The only thing they talk about is the state's treatment. Oh, Trevor Boy made
Go back to sleep.
That mocked Meredith. Yeah, how'd you find that out? Oh, right. She hacked into it.
My feet are falling asleep. He's getting so heavy.
Posted the extraction of it 2 days after they hacked into it. And it shows the locations of everyone who hacked into it from January.
It's all right, buddy. Go back to sleep. Go back to sleep.
Dumbass posted it because he wanted to show everyone the messages. Like, oh, come read the messages.
I'm trying to clean the floor. You're sitting. Hey. You're sitting in. I started to clean the floor. You come in and you sit down. How am I supposed to clean the floor? Huh? Oh my God. You can't come in here when I'm trying to clean the floor, dude. Like, yeah, there's stuff on the floor, man. Hey. Come on, man. Can you help me out? Oh my God. Is he the cutest thing you've ever seen in your life? I mean, come on. How am I supposed to clean the floor? Oh my God. Are you gonna help? Huh? No? Oh, yeah, you will. Okay. The mop's over there. Come on, man. You gotta help me out. Oh my God. Oh my goodness. You just want me to pet you all day. I mean, that's all is going on here, right? Yeah. Coming screaming at me. Are you gonna? You can't come in here when I start really cleaning the floor. Like, I'm gonna be mopping and stuff. You can't come in here like that. It's gonna be fabuloso on the floor. You can't have fabuloso on your paws and stuff, dude. You understand? Hey. You understand? Okay. I mean, I don't want to, like, have to lock you in the other room or something, dude. I don't want to do that. But you gotta let me clean the floor. Hey. Yeah, I get it. Okay, let me clean the floor now. No, huh? Okay. Is he the cutest thing you've ever seen? I mean, come on. He bullies me into petting him and letting him lay on me and sleep all the time now, though. It's getting to be a thing. It is getting to be a thing. All right, now we're going to go from cuteness to really ugly. Sorry.
Which was right, basically, oaths across the board. The messages say, police take an oath, lawyers take an oath. So in closing, now we have to ask ourselves this. You ready? Pay attention. In closing, the defense, in my opinion, lied for a reason because they had an opportunity. So it was like, here, right after this happened, which was right basically when the wheel's about to start going and the grease is getting on those wheels with Aiden Carney and the defense team, right? Boom, we're trying to gag you, right? And this is just right after, like, it just is starting. This relationship between Aiden Carney and Karen Reed and her defense team has literally just begun. And the Commonwealth comes out and they're like, we need a gag order. Like, across the board, obviously, everybody needs to be gagged here, okay? And so this is my question to all of you out there, is the defense, in my opinion, lied for a reason to avoid being gagged in May of 2023 because they fought that gag order at that hearing when they could have stipulated with the Commonwealth.
The Commonwealth.
They could have stipulated to keep, think about this. You took an oath.
That.
Okay. And I'm not going to lie for anybody. I'm not going to risk my fucking career for anybody.
The Commonwealth.
Right? So here you have an opportunity as a lawyer to just stipulate with the Commonwealth and say, hey, yep, you know what, dude? Say, talk to your team and say, hey guys, we're just going to stipulate. And stipulate means let's outside.
She wanted the defense to stipulate with the Commonwealth about a gag order. Why would they do that? This chick is so fucking crazy. She had 900 people watching her today. 900 people. It's a sick world, people. Be safe out there. Oops. Fucking did it again.
Right? The defense team fights against the gag. And in order to do that, in order to fight this gag and win it, they lied. They fucking lied. Right? How do we know they lied? Because Aiden Carney was not the source of any federal fucking investigation. The defense team was the source. Had Aiden write the articles, Karen Reed is blowing up Natalie saying, why isn't he writing more about the federal investigation? Write more. They need that to happen. They're feeding it over here to Natalie.
She gets everything wrong that she does. I swear to God. I don't know if she does it on purpose or whatever. But she is getting things conflated. And we're going to look at it.
Natalie in April, so that Natalie thinks that there's truly this intermediary going on, but there's really not. Okay? Because Aiden's already talking to the lawyers by April 20th. Why is Karen Reed down Natalie's ass in April of 2023 on April 27th and 28th? Who gives it? Like, because they're selling it. They're selling it to say, yeah, Aiden doesn't talk to any of us and Aiden doesn't talk to the attorneys. Nobody's talking to Aiden. Okay. But again, in real time and how it's looking, but here now with what we know, this isn't about what we think. This is the evidence. With what we know, my question is, in closing, the defense, in my opinion, lied for a reason. It was to avoid being gagged in May of 2023 because they fought the gag at that hearing when they could have stipulated with the Commonwealth. So as a lawyer, why would you risk your career and lie to a judge? If it wasn't for Aiden's big mouth, we wouldn't have been the wiser. And remember what I've been telling you guys is Aiden's not going down alone. If Aiden doesn't say that this is how this all transpired, this is why Tully couldn't get into Karen Reed's phones, because it was about you're speculating still. But now we got signal messages. Now we have Aiden's own words. And now we have a timeline. So let me ask you guys this. Why would the defense team fight against the gag?
Why
do it in a way that they know that they're going to be violating their own oath?
Team fight against a gag order.
The fuck would you put yourself into that position? No lawyer would ever do that. You would just see that we're in hot water right here, just right when this started, but they went out of their way to lie to the courts so there would be no gag order. And guess what then kept continuing on? What happened after May of 2023? That shit got turned the fuck.
Yeah, look at her chat. 932 people. Fucking amazing.
Up. Aiden Carney went ham. What does he do? Goes to John McCabe's kids' games. What does he do? They go out and get fake emails. They go out and get fake names. They go, think about what the fuck happened. They just started this relationship, supposedly on paper with what we have right now, in April 17th, April 20th of 20.
People that say supposedly, I can't take serious ever.
2023. You can say whatever the fuck you want about me. You could say this, that, or the other. But to every lawyer out there, this is indefensible. You cannot defend this.
Cannot.
They had and if you look at my thumbnail, it says May of 2023, a decision was made because they had the decision once the Commonwealth filed for that gag order. You knew that you were the only position that you could take to defend it if you were going to try to say we don't want to be gagged is to lie. And that's the position that they took.
So here she is.
After this happened,
she has gone full. I mean, you guessed it. I mean, we called this. What was my prediction? I think middle of April or the end of, or by May, she would be 100% Karen Reed guilty. And not only, well, she hasn't said that yet, but she's calling her attorneys liars in breaking the law. So I mean, you know, and then she's going to say a bunch of other shit. She's in the tank for the House defendants. That's what's happening with all these people. Okay. They hate Aiden so much that even though they believe in Karen Reed, they are willing to back the House defendants to see him go down. That is true Turtle Boy derangement syndrome right there. Free and clear. It doesn't get any clearer than that. I mean, the anti-Karen Reed people, yeah, you would expect them to be anti-everything. But this is the slant these people are taking now. It's fucking unbelievable. It's really not unbelievable. It's fucking wild is what it is. But yeah, palate cleanser.
But I also have seen how much the speaker their conscience, but I also have seen how much the speaker and Senate president can wield according to their conscience, but I also have seen how much the
Hear that?
Speaker
Hear that shit?
and Senate President
Yeah, let's back it up. Let's back it up. Oh, shit. Here.
can wield
Watch the face he makes. Yeah, he farted again. This is Cry Fart 2 Electric
according to
Boogaloo.
their conscience, but I also have seen how much the Speaker, how much have seen how
That's
much
it.
have seen how much
Tell
the
me.
Speaker
Look at the face he makes. Oh, that was
and
sour.
Senate
Oh, yuck.
President can wield
Incredible. Absolutely incredible. He did it again. He fucking did it again. People. That's Cry Fart 2 Electric Boogaloo. Brought to you by Causey G. Hold on, I got a text message here. Okay, whatever. All right, sorry about that. Yeah, those Cry Fart 2 Electric Boogaloo. Coming to theaters near you. All right, what do we got here? We got Lady 100, $2. Thank you very much. Appreciate it. Starting to show off strong. I appreciate it very much. Nicola Maxwell, all the way from Scotland, sending a funny looking a money sign and $2. The Commonwealth. Yeah, it drives me nuts when she says that. And we're going to be hearing it a bunch probably. Nicola Maxwell again, this time 227. Hustle Along to Dying Cold. Hit like chat fam, Lana hitting thumbs down. Yeah, no shit. I mean, I don't want to keep reviewing her, but we're watching the evolution of a spiraling lunatic in real time. And I've been covering it the whole time. Now she's completely calling Karen Reed's attorneys criminals. Okay? We're gonna see it. Oh, I already did that one. Thank you, Nicola. Oh, Winks and Wilts, always a good supporter. It's crazy how wrong these people are and how many people are following this garbage. Oh, yeah, it's crazy. 900 people in her chat. 900 fucking people in her chat. And this is Lady M100 again, but she used to support Turtle Boy. What happened? What caused such a 180? She came up with some cockamamie harebrained theory, and he rebuffed her, and Karen Reed ignored her, and she went insane. And then she was given the phone extraction somewhere around October or so, and she has been Turtle Boy jail prison ever since. It's that easy, just like most of them. Yeah, pretty fucking crazy, man. Pretty crazy. But yeah, let's get into it, people. Do I have anything else here? No, I don't. So we're just gonna look at what Lana had to say, man, and there's a lot more. Okay. All right, let me kind of do this because I had to start the stream over a little while ago and lost a few things. So give me a second. Go here. Is Turtle still on here? No. Okay. It must have just ended. All right. This is fucking crazy. Here. Start at the beginning. Do you guys care if you see the chat or not? Because I'll leave yours up. I mean, some people like to look at it. They like to zoom in on it, but whatever you tell me. So as Lana goes along, this is going to be the hearing she's talking about. And let's see how wrong she gets it. And if you guys can tell me before I tell you exactly what she's getting wrong, I'm sure you will. I mean, she claims to be so knowledgeable about this case. Fucking. Oh my God. I didn't even share the fucking screen yet. Oh my God. I'm so horrible at this. Can you guys hear it? Oh my God.
No clue.
Could you guys hear anything?
In actuality, is communicating with.
I know, Baker.
the defense
Thank
team.
you.
In fact, they went out of their way to tell us all that they
When
were
I
not
get the hang of
communicating.
this thing, I'm
Okay.
telling you, I'm
And at
going
the
to
end
be
of
a
May of
force to be reckoned
2023,
with.
that is when the defense launched the Free Karen Reed Defense Fund. Donate to the fund. We're going to raise funds, and it's going to be a crowd funded pot of money that is basically like, hey, you're fighting for your rights as well. Karen Reed
I've only been doing it for like 5 months, so I mean, I almost have as much trouble as Turtle, but
was framed. This is how this played out, right? And in fact, it was not only did they use Turtle Boy, which we're going to get into here, that big old poster that was hanging up there, that Sean McCabe shit. Who's that communicating with? How do we know that that's even Sean McCabe's social media? Because we've witnessed Turtle Boy make up people's accounts, okay, and make themselves a certain.
So now she's claiming that Turtle Boy made up the Sean McCabe account where he threatened to bury Turtle Boy under Auntie Bev's oceanside cottage down the Cape. He made that account up.
Certain person, and then
Even though Sean McCabe is fully admitted to what he said, but whatever.
and have conversations with themselves to frame other people. This is not an opinion. This is fact. He did it in the Ryan Waters case. He created an account called Ryan Waters, then used his own kids to create.
That's a lie.
Ryan Waters was going to basically
Didn't happen.
Do bad things with his children, but don't worry, I'm going to bring them back.
In her chat, you can,
then sends this to
you can
his
see
attorney.
the chat. A lot of them are pushing back, but like, you know, the blue ones are like, oh, Lana's a truth teller. She's nailing it. Like, they're so fucking dumb.
They then want to use this as evidence to be able to get a guy that's suing him. Hey, we're going to handle him like this. Okay, now, so much so, there was extrajudicial statements made after the May 3rd hearing, Attorney Jackson and Attorney Yannetti go out on the court steps and they give a nice little rant, start asking questions, blah, blah. And then it talks of this federal investigation, this federal grand jury. Then how they cited in court is that, wait, we didn't put that out
Yeah, she is getting info from Kate.
there. We didn't tell the world about
She
any
loves
of this
her
stuff.
some
We don't
Kate,
know,
man.
we don't know anything about anything like that. We got the information from the media. So back in 2023, we got this information from the media. Yannetti and the team write up a motion where in this motion they cite Turtle Boy. Okay. They cite Turtle Boy as the source for the information about this federal grand jury / investigation.
But she's wrong. Turtle Boy is the source of the Sean McCabe comment or tweet or whatever he got from him for the motion to recuse. He's not talking about the FBI investigation.
He's our source.
She gets this all wrong. It's incredible. She either knows that she's doing it or she's fucking 1,000 times more stupid than I thought.
And that's why we're talking about it. Now listen very closely. In a courtroom, the Commonwealth is like, we need a gag order for this extrajudicial statements. They're going out and talking about the defense team they were not for this gag order.
The defense wasn't for this gag order. Show me a defendant that's against a gag order. I mean, in certain situations they are because they want to protect the rights of the defendant. But a lot of the times they want to get shit out there. Why didn't they stipulate to the fucking gag order? What?
Now this is in May. So between May, at the end of May.
Her and her timelines. Her timelines mean shit when you get all the information wrong. Her timelines might be correct, like as far as time is concerned. But why it matters, she gets wrong every time in every case I've ever seen.
May and July, right? The Commonwealth is like, they need to be gagged. We all need to be gagged. So think about this. In 2023, hey, we can just stipulate. You're the defense team, talk with the Commonwealth and say, hey, let's just come up. Let's all stipulate to this.
It drives me insane.
That was a choice that could have been made. The defense team could have said, hey, let's just go ahead and stipulate to this. Gag order. That's not the decision that was made. The decision that was made was, no, we're going to fight this. Okay?
Yeah. Usually I'm not like a hit the like person, but like my videos, like I think last week I got like 5,000 views on a stream and I got like 400 likes or something like that. Just please hit the like button. Takes a second and doesn't cost.
We're going to fight this.
I'm not sure what it does, but
we don't want to be gagged.
Please do.
And we're going to fight this. And that means we're going to be writing a motion. And not only are we going to be writing a motion, but we're going to then argue in support that we didn't do anything wrong. And that's what this ending right here is about. When David Yannetti takes the podium.
To relieve counsel from doing our jobs. How dare they ask this court to take away our First Amendment right to free speech?
Now the judge.
You guys remember that when he goes on and on?
Yeah. I do. Remember it well.
What they do is they supply to the courts a timeline, which is Aiden Kearney, aka Turtle Boy Daily News, puts out a blog between April 23rd and April 28th of 2023. Then here's Alan Jackson statements on the courthouse steps in May 3rd of 2023.
But she's fucking wrong. Like she, forget it.
So how it looks on paper is blogger writes this article. He's our source. This is why we're talking about it. Then both sides are arguing their positions, which would require candor to the tribunal. You have to be truthful in your statements. And here is where I could not believe, and we would not be able to understand this until 2026 because of Aiden's big mouth. What I could not believe here is, because I'm all for it. Yeah, they're advocating for their client. Like, what do you mean? Like, they just told us here. There was media is talking about it. that's their source is media, because this is what the defense is saying. It's like, absolutely, yes, right? Well, Beverly Canone denies the Commonwealth.
The Commonwealth.
Okay, in July here, denies the Commonwealth where there's not going to be a gag, because you basically
she said
you can't prove.
She tries to sound smart. Candor to the tribunal. It says shit like that. Like, everybody knows those fucking terms, bitch. It doesn't make you smart. It actually
Prove that the defense is making extrajudicial
things
statements.
he comes up with
wrote a motion and
insane.
said, wait, we got our information from TB Daily News. They put that shit out in April. We then talk about it at the beginning of May because of the article.
They're not talking about the federal investigation, though. That's what you're getting the whole thing wrong.
And like, you can't gag us. Like, we
She's
didn't
a liar.
Attorney Jackson did nothing wrong here.
I think
he got his information
This is
from
straight liar.
the media. We're simply repeating what the media has put out. Now, Turtle Boy would then get arrested in October of 2023. There's no gag then. So Turtle Boy would then get arrested in October of 2023. All of his devices would be seized.
Right.
Turtle Boy then is let out the next day. The reason that he gets rearrested and then bail revoked is because he got another charge. And so he did his 60 days because of
Lindsay
being out on bail.
Right.
He violated his terms and then had to do 60 days. Then he was released. In January of 2024, which is right after the holidays. See,
her chat buys this shit because she's like, she's got this timeline. Oh, on August, 30th of blah, 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 blah. You know what I mean? And it's like, oh, but they don't do any. They're not aware of any of this shit, so they just buy it.
Tully writes up some very, very long search warrant affidavit and is writing down, and he, for the first time, and when we finally get the information, Tully puts that beginning April 20th, 2023, Alan Jackson and David Yannetti are actually in the phone records prove that Turtle Boy has actually began to talk to them on each one of their personal devices beginning on April 20th. This would be prior to.
By the way, keep in mind, she wants us all to go towards like a civil defamation case. You know what I mean? Like, bitch, the 2 trials are already over. It's not guilty. Okay. I don't know, what do you expect to happen here?
Prior to on April 20th is prior to any written article of this federal investigation, this federal grand jury being written. They have 9 phone calls between one of them and 11 between the other one. And that was between April 20th and May 3rd. And so Tully writes this as part of his affidavit because he is trying to seize, not search, but just seize the devices of Karen Reed.
The only way they can search him is if they seize him, dummy.
January 2024.
I can.
Okay. And so he writes that we're able to get this information that they were 1000% talking, right? But guess what? You can't just go ahead and prove. You can't just say, what the conversation was. Like, basically, who supplied who with the information of this federal
the phishing
investigation?
Yeah, we get
was it Aiden Carney that on the phone told them, or was it the defense team that on the phone?
You didn't hear the conversation.
Carney? You don't know who the supplier is.
Right. We get it. Yep. Go ahead.
And so Karen Reed's phone, they were seized, right? But they never were searched.
Okay. Yeah, sure.
And then as time would go on,
we know the phones were searched. Get the fuck out of here.
And it would not be until Aiden decided to come out and tell the world here with his big mouth that Alan Jackson is a genius.
So,
and how this all played out is that they gave me the information. I then wrote about it.
Yeah.
They then use me as the source to then bring it into the courtroom.
No.
Courts.
No.
Okay.
That's not
and
correct.
This is how you circumvent.
It's circumvent. Oh, you're circumventing. Okay, I get it.
And
chick's a fucking idiot.
We're going to get into why you should.
And by the way, the request to debate me either on her show or my show have gone Unanswered. Nothing from her.
Care. I don't care that the defense leaked information.
And
But the way
she's gone on record many times. She's like, I'll debate anybody about any of the cases I could. I'm like, not me.
It was really stupid. Okay. Well, here's what I'm going to say.
With her fucking stupid backwards hat. She's fucking disgusting.
Now understand this. This is what all of you guys need to think about. I wrote a Twitter. To two people that I fully respect. It was under Bob Mata's post, was under Defense Diaries. And let's see.
No, she replied to me one time.
I'm going to give it to you.
I actually, I screenshot it. I said something. She said, calm down. Don't come over it or something like that. I'm like, you're fucking gross. Like, don't come over it? Who fucking says shit like that? It's a nasty bitch.
Just as I put it out on Twitter because it lays it all out perfectly. I said, let's see.
Listen, I'm going to tell you right now. Yeah, she does like the Matas, and I think they like her too, and that's a problem I probably have with the Matas. I mean, if you in any way listen to this fucking idiot, I mean, I love the Matas, and maybe they don't know the ins and outs, but she's a scumbag, and everybody knows it, and I hope they don't like her.
Replies. Okay. I said, thank you for responding, Bob and Alex.
Too bad.
As far as number 3, so I have to tell you my original post, which was on them, underneath their.
I love Defense Diaries.
Where was it? Okay.
I mean, she got Delphi right. You know what I mean? Whatever. I mean, a broken clock is right 2 times a day. You know what I mean? She got Delphi right. I mean, it wasn't really a hard one to get wrong.
Because it was very helpful.
All right. Good night, Jordan.
Defense Diary says, as far as number 3, which is I made 3 or 4 points. As far as number 3, I believe the sanction for the lack of.
I'm not judging them.
Was regarding the payment of funds to ARCA.
I'm not judging anybody. I'm just saying, like, they might not know how fucking terrible she is. Maybe they don't pay much attention to her.
So Bob is over here and Allie are over here thinking that I'm referring to Canada the courts.
Right, Andrea.
The payments to ARCA, that would be in 2025.
They're too busy being fucking awesome doing other shit.
So Defense Diary says that may be dealt with in the future by a disciplinary committee in California. Jackson would have the opportunity to defend his position. I don't know that relationship between the defense and Aiden was ever addressed by the court. I'm fairly certain there was no candor to the court sanction regarding that subject matter. So I said, okay, thank you for responding, Bob and Allie. As far as number 3 goes, I am referring to a time frame that is before any expert with this case was involved. You guys know me, and I'm all about the timeline, so I start from the beginning. So
I don't know if they know about the Watt stuff. I don't know.
Point number 3 is about a very specific time
I would
frame.
think they have to.
The federal grand jury, the feds were investigating the investigation announcement by the defense on the courthouse steps on May 3rd, 2023. My personal vetting that I've done and the research that I've done, here it is. April 20th, 2023. The first phone calls between Aiden and the lawyers for Karen Reed begin. 9 calls for Jackson and 11 calls for Unity with Kearney from April 20th of 2023 to May 3rd, 2023. My source is the search warrant affidavit application by Tully, and he's using he's using Aiden Kearney's extraction. Now, 4/23/2023 to 4/28/2023, Aiden Kearney writes a blog saying that Jen McCabe is or has testified in front of a grand jury. This blog is written.
David, calm down. I just said I wasn't judging them. That's all. Relax, man. I wasn't raising my voice.
After numerous calls between Aiden and Karen Reed's defense team, Tully could not use Tully could only use the circumstances of the phone calls existing within his affidavit to obtain Karen Reed's cell phone in January of 2024, because he obviously didn't have the content or the context of the phone calls. May 3rd, 2023, a hearing took place in Norfolk County Courthouse. Karen Reed's defense team was there. After the hearing, the defense team took to the courthouse steps and spoke about for the first time publicly.
I think maybe they don't know the extent of her shittiness. Maybe, they probably don't have time to look into Lana. I mean, only I have time to do that.
After this hearing / this date, the Commonwealth put in a motion to have a gag order due to the defense making statements that were quote unquote extrajudicial in nature. This required them to come back at the end of May. At the end of May 24th, I believe, 2023, they were all back in the courtroom for a hearing where Yannetti, prior to the hearing, filed a motion and cited Turtle Boy Daily as the source for what Jackson spoke about on the courthouse stairs on May 3rd, 2023. Yannetti, specifically then, when he comes out right here, and he stated that they had no knowledge of any federal investigation. He said, how could they? Yannetti said that he was adamant, this is our First Amendment, we're going to advocate for our client. How dare the Commonwealth take that from us? Yannetti said that...
Yeah, but that's not what he was talking about. We're going to watch it.
Their team became aware of the federal investigation from the media. The media they cited was Turtle Boy Daily News in the footers. These are the statements and written work of the defense that I am writing about and referring to as in violations of professional conduct, Rule 3.3A1, candor to the tribunal, Rule 3.6, trial publicity, and Rule 8.4, C and D,
She's
professional
terrible.
misconduct.
She's absolutely terrible.
Bev ruled that she would not recuse herself because of rumors and online people making shit up, which we have to understand.
Making shit up.
Came after the spectacle right here. Now
The spectacle.
These are the statements and written work of the defense that I am writing about and referring to as in violations of professional conduct, Rule 3.3A1, candor to the tribunal, Rule 3.6, trial publicity, and Rule 8.4, C and D.
This lunatic who, amongst a lot of other things, mocking a dead, pregnant, murdered wife of Chris Watts, coming up here, like citing rules of professional conduct. Get the fuck
Professional
out
misconduct.
of here, dude.
Bev ruled
You dirtbag.
that she would not recuse herself because of rumors and online people making shit up,
Online people making...
which we have to understand came after the spectacle right here. Not only did Bev rule on that, right?
No,
Bev
it came the same day as the spectacle.
then ruled that there would be no gag order she was going off of the defense's written work and analyzing it and how you have to do things. You can't just rank speculate and blah, blah, blah. Bev says, yeah, we're not putting a gag order on anybody. Nobody deserves to be gagged here because nobody's in violation of anything. No one's doing anything wrong. We're not in fear of anybody doing anything wrong. So Bev ruled no gag order because the defense was able to cite a media source, which on paper at the time looked real good.
I don't think this is what she's talking about is correct. But even if she is correct, it doesn't matter. It doesn't matter. That part of it, I need to dig into because I think she's conflating the message about Turtle Boy being buried under the fucking cottage. I think she's conflating these issues.
Between 423 and 428 at the time. So this is how it looked for Bev. Hey, the media's writing this. The lawyers say it afterwards. Okay. That's how it looks to Bev. And so before, in 2023, this chronological order of events, well, it looked like the defense was being honest. They used a media outlet to source them, the defense. However,
like being honest.
We now know for a fact that is not true. How? More forensic digital evidence, phone calls with the defense team and Aiden would be revealed in that time frame. And of all of that, then Aiden's own mouth. However, when Tully wrote up his search warrant for Karen Reed's seize only instructions, we're not going to be searching anything, it was due to speculation as to who really or what really came first. Was it Aiden truly being the source?
Toy, not only Bev is a hero, the Commonwealth were cheated, right? They were lied to. They were cheated out of a fair trial. Okay? Across the board. It's wild.
Even though those phone calls are there, that's still speculating. Or, so this is why Tully couldn't get into the phone, or was it the defense team providing Aiden? Well, that gets eliminated. When? Not till 2026. How? Because Aiden decides to run his fucking mouth and say, well, until Aiden Kearney decided to tell the world how genius Alan Jackson was, which came in the winter of 2026 by outing that the defense was Aiden's source and that Aiden wrote the article, and then the defense used Aiden's blog to circumvent, to be a continent. So you cannot do this. Okay. Now, this is why I feel the way that I do. This has led me to my opinion that everyone has dirty hands in this case. Everyone. It has nothing to do with First Amendment or lawyers being able to talk to whomever they want and advocate for their clients. It has to do with oaths across the board. The Massachusetts State Police take an oath, lawyers take an oath. So in closing, now we have to ask ourselves this. You ready? Pay attention. In closing, the defense, in my opinion, lied for a reason because they had an opportunity. So it was like, here, right after this happened, which was right basically when the
hear that, everybody?
when the wheel's about to start going and the
Defense lied for a reason.
grease is getting on those wheels with Aiden Kearney and the defense team, right? Boom, we're trying to gag you, right? And this is just right after, like, it just is starting. This relationship between Aiden Kearney and Karen Reed and her defense team has literally just begun. And the Commonwealth comes out and they're like, we need a gag order. Like, across the board, obviously, everybody needs to be gagged here. Okay. And so this is my question to all of you out there, is the defense, in my opinion, lied for a reason to avoid being gagged in May of 2023, because they fought that gag order at that hearing when they could have stipulated with the Commonwealth. They could have stipulated.
She's so dumb.
You took an oath. Okay. And I'm not going to lie for anybody. I'm not going to risk my fucking career.
Oh, no, Lana, you are just, above board, just the best of the best. One of the best that's ever done it. You piece of fucking garbage.
For anybody, right? So here you have an opportunity as a lawyer to just stipulate with the Commonwealth.
Hey, Sarah Jane, 900 people today. 900 people.
And say, hey, yep, you know what, dude? Talk to your team and say, hey, guys, we're just going to stipulate. And stipulate means let's outside of the court say, hey, we agree. And that we're both like, yep, let's have this gag. And then the judge would have been like, okay, yeah, here you go.
It's
right?
a judicial agreement, you fucking
The defense team fights against the gag.
Yeah.
And in order to do that, in order to fight this gag and win it, they lied. They fucking lied.
She's
right?
calling them liars.
How do we know they lied?
Alan Jackson,
Because
David Yannetti, Eliza Little.
Aiden Kearney was not the source of any federal fucking investigation. The defense team.
They never
was
said
source.
he was. Like,
Had
what
Aiden
is she talking about?
Write the articles. Karen Reed is blowing up Natalie, saying, why isn't he writing more about the federal investigation? Write more. They need that to happen. They're feeding it over here to Natalie in April so that Natalie thinks that there's truly this intermediary going on, but there's really not.
It's really not.
Okay. Because Aiden's already talking to the lawyers by April 20th. Why is Karen Reed down Natalie's ass in April of 2023 on April 27th and 28th?
Because it's like a few days later. What the fuck are you talking about?
They're selling it to say, yeah, Aiden doesn't talk to any of us, and
They're
Aiden doesn't talk to
selling
the
it.
attorneys. Nobody's talking to Aiden. Okay. But again, in real time and how it's looking, but here now with what we know, this isn't about what we think. This is the evidence. With what we know, my question is, in closing, the defense, in my opinion, lied for a reason.
See, what I think she does, right? Because she has the extraction, right? And everybody knows it. She's going to go through it and she's going to try to come up with shit that nobody's said yet, that she knows is wrong. Right? Because you become special if you do that, right? She always wants to be this person that finds something that nobody else has found. And it's always wrong, or it always doesn't matter. And I think I've figured her out. I think that's what she does. And she covers like a shitload of different cases. Like she goes live like 4 to 5 times a day on different cases, all different cases. And I think she draws a bunch of people in from these different cases and she finds all these weird little anomalies with him, blows him up to be like this timeline bullshit that doesn't matter, and people are like, oh my god, she's really figured it out, she's super smart. It's just all bullshit.
And it was to
Hey,
avoid
thank
being
you,
gagged and
everybody. We just met the goal. Yeah, confetti just flew. I've seen that a couple times before. I appreciate it. Thank you very much. We'll go through that in a couple of minutes.
May of 2023, because they fought the gag at that hearing when they could have stipulated with the Commonwealth. So as a lawyer, why would you risk your career and lie to a judge?
Lie to a judge.
If it wasn't for Aiden's big mouth, we wouldn't have been the wiser. And remember what I was telling you guys is Aiden's not going down alone.
She claims that because he said Alan Jackson's a genius, that what? I don't get it.
If Aiden doesn't say that this is how this all transpired, this is why Tully couldn't get into Karen Reed's phones, because it was about you're speculating still. But now we got signal messages. Now we have Aiden's own words. And now we have a timeline. So let me ask you guys this. Why would the defense team fight against the gag?
You see what she's doing
but
here.
Do it in a way that they know that they're going to be violating their own oath.
You see what she's doing here. She wants to bury Karen Reed. I mean, the fact that she's still sitting here saying she's free Karen Reed is fucking incredible.
Why the fuck would you put yourself into that position?
Who the fuck?
No lawyer would ever do that.
Shut the oh my god, I can't stand her. Like acting like she's pissed. You know what? Fuck it. Hold on a second. Let's see what this bitch does. Let's see what this bitch does. She's so upset. Oh my god. I can't believe it. This fucking piece of garbage. There you go.
Picking at a nursery starts with color. The room has to just be.
Fucking scumbag. I ain't done yet. And she's upset. She's offended. Scumbag. Absolute fucking scumbag. Has a nerve. Where is it? Where the fuck is it?
It's Friday night. I'm just getting ready for my Tinder date. Me and Chris decided that we're gonna do this whole open marriage thing. So I got a new lifestyle membership, and I'm just really excited to explore it, I think, a little bit. But with it being such like a long week with the election. Hey Sharon, oh my god. Hey, I know somebody reported the cream of some young guy. I can't even believe it. It must have been that shitty of a guy. Like, who would ever report the cream of some young guy? Anyways, guys, I just, it's been a long week, like I said. I'm just gonna let loose. I think I'm gonna adopt a child. I just got so many amazing ideas for 2021.
She's
I'm just really
offended.
looking forward.
He's disgusted.
You know, reinventing myself, getting out of my comfort zone. Thanks, guys.
What a fucking piglet. Oh my God. What a piece of garbage. All right, let's keep going. Why do I do this to myself all the time? Where am I? Yeah, I did it. Okay.
You would just see that we're in hot water right here, just right when this started, but they went out of their way to lie to the courts so there would be no gag order. And guess what then kept continuing on? What happened after May of 2023? That shit got turned the fuck up. Aiden Carney went ham. What does he do? Goes to John McCabe's Kids Games. What does he do?
So what?
They go out and get fake emails. They go out and get fake names. They go, think about what the fuck happened.
You know what she's really super pissed about?
This just
She's really super pissed about when Richie from Microdots and Aiden went to the lacrosse game. They bought tickets under another name so they wouldn't be found out. They wouldn't know they were coming. She's disgusted over that.
They just started this relationship supposedly on paper with what we have right now
Supposedly.
in April 17th, April 20th of 2023. You can say whatever the fuck you want about me. You could say this, that,
You're
or the
a
other.
piece of shit.
But to every lawyer out there, this is indefensible.
Indefensible.
You cannot defend this. They had and if you look at my thumbnail, it says May of 2023, a decision was made because they had the decision once the common. You could take to defend it if you were going to try to say we don't want to be gagged.
We're going to stop her right there for a minute. Okay. I'm going to stop her right there for a minute. We're going to go right to the source. Okay.
Clothing. It's now.
All right, I'll hear you.
Thank you, Honor. May it please the court. We are seeking immediate access to John O'Keefe's clothing, to all evidence seized from my client's vehicle, to tissue and other samples from John O'Keefe's autopsy, and to the original Canton Library video, which we still do not have. We are asking this court specifically to set a hard deadline for access to this mandatory discovery and evidence.
Exactly. I mean, what is that going to prove? And she's trying to say that somehow the defense lied about the gag order and that somehow lent to more defaming of the. I don't even know. This is what I'm telling you. She does this shit.
Your Honor, at the outset, it is important for me to emphasize why a deadline needs to be set. It's important to emphasize why time is of the essence for our access to this.
My blood pressure is fine, Oasis.
My client was arrested.
My blood pressure is always. I can't stand these fucking.
Prior to 15
I can't
months ago, my
stand
client
them.
was employed in 2 prestigious positions. Prior to 15 months ago, she had a robust health insurance plan that covered her numerous serious medical conditions. But 15 months ago, she lost everything. 15 months ago, these false allegations began to destroy her life. And for the last 15 months, she has been fighting for her life. 15 months after her arrest, she has no income. She does not come from a wealthy family. Her father was a respected and now retired educator. Her family is very squarely middle class. But given that Karen Reed is now fighting for her life, whatever money that they've saved is all going to her defense in this case. She's hired private counsel from 2 coasts. She's hired multiple experts at considerable costs. And when I say considerable, I mean tens and tens of thousands of dollars. And the meter is running with each passing court date. She can't afford to scrimp on her defense because her life is at stake. In the 11 months that
this is the thing. Like if Lana, you know, with the whole turtle hate thing, a lot of people hate him. All right. Like it's just the way it is. But what she's doing is now she is calling David Yannetti, Alan Jackson, and Karen Reed liars and conspirators. To basically where Turtle Boy was just like, you know, a useful idiot to them. They sent him out. It's fucking crazy. She calls herself Free Karen Reed, though. It's wild.
Pending in this court, we have continually asked for access to the same basic mandatory discovery evidence. We've been prohibited from inspecting that evidence. In February of 2022, the police seized John O'Keefe's clothing. It's now May of 2023. We haven't seen it. We haven't inspected it. We haven't been able to test it. In February of 22, the police seized pieces of taillight from my client's vehicle, pieces that they claim to have found at the residence where John O'Keefe died, despite the fact that multiple searches initially turned up nothing. Pieces of the taillight were only found after Trooper Michael Proctor, conflicted Michael Proctor, had seized my client's vehicle and had it in his possession for well over an hour. That evidence needs to be put to the test, and it needs to be put to the test now. We have been prohibited from testing it, from inspecting it, from even seeing it. There were tissues and other samples from the autopsy of John O'Keefe to which we've been denied access. We believe that when those samples are tested, the results will be exculpatory, likely case ending. But 15 months after she was arrested and 11 months after she was arraigned in this court, that evidence remains hidden from the defense. The police have maintained exclusive control over the event data recorder and the Lexus infotainment system from my client's vehicle. We have seen neither, and this is simply unacceptable. Prohibiting the defense from inspecting this evidence is infringing on my client's.
Well, her position is this: once she actually says, you know, Karen Reed guilty, she knows she's putting herself in a whole different category. She just hasn't said it yet, but everything that you're going to hear after this says it. I mean, she's been saying it for a while now.
Constitutional right to a speedy trial, and it's infringing on her right to due process. It's almost 3 months ago that we last appeared before you, Your Honor. We requested access to these items, and yet again, the response from the Commonwealth was that they would be tested soon. The prosecutor had represented within 30 to 60 days. That's on record. It's now close to 90 days. We've made zero progress. This court did order that the Commonwealth request expedited testing, but that order has yielded nothing. I asked the court to set deadlines then, which the court was not inclined to do. 3 months later, it is crystal clear that deadlines need to be set. Without a deadline, we have no assurances that this case will not drag on who knows how long into the future. With each passing day, my client, who not only is presumed to be innocent, but is factually innocent, remains jobless, with inadequate health insurance, and with each passing day, her savings and her family's savings continue to be depleted. There is no time to wait. There is no time to waste. It is time for excuses to end. As we noted in our motion, the prosecution and the crime lab move very quickly when they want to. In other cases pending before this very court, the very same investigators secured DNA testing within 2 weeks of opening their investigation before anybody was charged. Contrast that with our case, where here we are 15 months later, no such testing has even started. Regarding the Canton Library video, this court should know we still do not have relevant time periods. From the Commonwealth's evidence, we know that my client drove by the Canton Library at 12:16 a.m. on January 29th because that was recorded. There is video of her driving by at that time, heading to 34 Fairview, which is where John O'Keefe died, with her taillight intact. We know that my client arrived back at John O'Keefe's residence at 1 Meadows Ave in Canton at 12:41 a.m. because the Commonwealth produced a voicemail that she left for John, where you can hear the garage door closing, the car door closing, the house door closing while she walked in her high heels on the garage floor. 1 Meadows is about a mile from the Canton Library. We know the video equipment was working because they have that footage from 12:16 a.m. But in the video that the prosecution turned over to us, there is a gap in that video from 12:37 a.m. to 12:39 a.m., which would have been the precise time my client would have been driving back past the library. We know that that footage would show that my client's taillight was still intact at that point because she never struck John O'Keefe with her vehicle. Yet the prosecution has produced a video from the library with that crucial time period missing. This evidence is strictly in their possession. We've been told that the Canton police provided the evidence to them via a share file. The Canton Library provided this evidence to them via share file.
But Lana doesn't want to talk about all that shit, right? She wants to talk about the Commonwealth. Got cheated. Fucking come on.
Link with a guest ID and a guest password. We need that link, that user ID and that password. We cannot rely on trooper Michael Proctor, conflicted Michael Proctor, to sanitize exculpatory evidence before sending it to us. We need the original footage. If the Commonwealth answers that that original footage no longer exists, then we'll need an evidentiary hearing to put the relevant parties under oath to find out what happened to it. The bottom line here, Your Honor, is that we've spent 15 months trying to uncover the truth. We are not afraid of whatever evidence is unearthed from whatever.
Man, she hated Yannetti, but then Jackson came and took over.
Source, because for
not took over, but she just, her hate switched all over to Jackson.
15 months, every stitch of evidence has been consistent with my client's innocence. However long this case lasts, and I sure hope the prosecution comes to their senses and realizes they have no case because they've charged the wrong person. But however long this case lasts, the remaining evidence will drive a stake through the heart of this prosecution. In the meantime, my client suffers. In the meantime, her life is on hold while she spends every waking moment defending herself emotionally, intellectually, and financially. We cannot abide by excuses any longer. We need this court's help. We need you, Your Honor, respectfully, to hold the prosecution's feet to the fire. We need this court to order the Commonwealth to stop trampling on my
standing room only,
to a
man.
Speedy trial and her right to due process. We need this court to set deadlines for the production of this evidence.
Okay, thank you. Mr. Lally?
Yes, sir. So in response to counsel's
Oh,
motion,
God,
just
Lally.
in response to the statement that every piece of evidence that's been provided thus far is inconsistent with the defendant's guilt and consistent with their innocence, I would have a large issue with that. But as it pertains to these particular pieces of evidence, counsel's right in that motion was filed. Counsel's right in that motions were allowed when, as related to inspection of said materials, the Commonwealth has no issue with inspection of materials once they're back from the lab. Now, the last time we were before this court, back in February, the court had asked myself to reach out to the lab and see if there was anything that could be done to expedite the analysis. I did that, spoke.
Was this the day of the, because you can hear the shit in the background, was this the day of Free Billy Tibbets? I don't know, it might have been.
With and filed the necessary paperwork with the lab to expedite as much of the analysis that could be done at that particular time. So at that time, what I was provided with was a deadline of no later than May 5th. Those items, at least as far as the trace analysis and the criminalistics was concerned, would be completed, and I should expect something close to that date. I confirmed with the lab as of yesterday that that timeline is still a viable one. The case is currently in technical review, so once that's completed, then we should have reports that I'm able to provide to counsel. As it pertains to the inspection and the return of the items from the lab to the Commonwealth's, well, at least the district attorney's office for the state police's custody, one of the issues that we've had with that is that in order to facilitate some of the necessary DNA testing, some of that testing would be exhaustive. And in particular, there is a hair sample that was recovered from the rear right quarter panel of the defendant's vehicle. It was taken to the lab, and I was informed by the lab that any testing of that for DNA for comparative purposes to Mr. O'Keefe would be exhaustive. So on March 10th, I sent counsel a exhaustive testing form that needed to be filled out, whether or not they wanted.
Remember all the shit that Lally fucking dragged his feet on, like, forever? Like, we forget how bad he was. You know, I think a lot of people do.
Present for that testing, or don't want an expert for present for testing, is really immaterial, but I need some sort of authorization from counsel before the sample is subsumed during the course of testing with the lab. I haven't heard anything back from counsel. I spoke to counsel numerous times. I sent emails, and I heard no response as far as that. So as far as the DNA testing is concerned, the delay on that is because I don't have anything back from counsel as far as whether or not they want an expert present, who that expert is, how to contact them, and how to facilitate the beginning steps of that particular testing. So that is why, at least in no small part, why some of the items are still contained at the lab is because the testing is still yet to be completed. But I do hope to have the trace and the criminalistics, and I expect that by next week at the latest. And again,
yeah, right.
Whatever deadlines that the court sees fit to or deems fit to put on certain things, as far as that's concerned, is certainly within the court's prerogative. I don't think that we need deadlines. I don't think that we need an evidentiary hearing as it relates to it, but that's where it stands. As far as the video is concerned, the video.
Lally's probably happy as a clam, you know, making his, you know, close to 200 grand a year, you know, just fucking, you know, sending people to jail and fucking prosecuting people, eating his cheese sandwich and going home at 4:30 every day.
Was provided by the IT director for the town of Canton. There was a share file that was shared with the troopers. The troopers, upon receiving that, it was Trooper Dunn who received that video, not Trooper Proctor. If I could just speak briefly as it pertains to Trooper Proctor, there is no conflict. Trooper Proctor is not conflicted in this case. I indicated that some of the opposition. That didn't age well, did it? Filed to Rule 17. So there's been some photograph taken from a social media site, which is purported to be Trooper Proctor with one of the McCabe's children who are a witness in the case. The child that's depicted in that particular photograph is not one of the McCabe's children. The McCabe's have 4 daughters. That's not one of them. It's a relative of Trooper Proctor. It has nothing to do with the McCabe's and nothing to do with this case. Whatever conflict counsel believes Trooper Proctor has, this doesn't exist. Now, as far as the video was provided to Trooper Matthew Dunn of the CPAC unit with the district attorney's office, that was then shared with Ms. Crawford. It was a person in our office who specifically who deals with forensic and surveillance video and type evidence. It was then archived on our system. Recently, we reached out and spoke to the IT director with the town of Canton again. That share link I tried to send to council, email essentially wouldn't go through. We tried to open it.
Oh my God.
So the link,
in this day and age, can you imagine, like, we can't open the, you know, it's not the right format. What the fuck? Are you kidding me?
Expired within 30 days within 60 days, if not 30 days of it being shared with our office. But the exact information that was provided by the town of Canton was archived by Ms. Crawford, was then provided to council at her arraignment in Superior Court, as well as I was able to download it onto a Citrix file, which I then shared with council earlier this week. So What we have as a video, what exists as a video, what we were given as a video for those relevant time frames was placed onto the archive within our system. Was then
Like
placed onto the disc.
it is such a bad look. Like when people say the prosecutor is connected to the judge's bench, and they don't even they have their back to everybody. It's so fucking offensive, man. It really is so bad.
The disc, what's been provided to counsel, is what we received.
All right, your next motion?
That would be Mr. Jackson.
Okay.
Here comes the hatred. She's like, you son of a bitch. She can't hide her
May
disdain.
it please the court, we are, as indicated in our papers, we are seeking summonses, and this is dealing with the animal control issue.
Now tell me he hasn't aged, right? I mean, listen, I think this trial took a lot out of them.
That Rule 17 motion, we're seeking summonses directed at two entities, the Canton Animal Control and the Canton Town Clerk, both. We believe they both have records. We know they both have records. These are records that we need, the defense needs, to shine a light on Karen Reed's innocence. These are records that are central to our theory of the case, and these are records that we have no other option to get but through a summons. They've indicated to us they have the records, but they need a court order. They need some sort of a summons. Your Honor, in furtherance of this motion, I want to talk for a quick second about a couple of
Oh
other
yeah, he
things.
looks good. I'm just saying.
On January 29th,
a couple years.
Officer
You know?
John O'Keefe was found dead in the yard of Brian Albert at his house at 34 Fairview in Canton. That is undisputed fact, where he was found dead and what the circumstances were surrounding that death are why we're here now. Second undisputed fact, when John O'Keefe was found, he had this set of wounds on his right
This
arm.
drives her absolutely insane.
The medical examiner indicated that these wounds were concomitant with his death in terms of the temporal, the time that he died. These were wounds that he suffered at or near the time that he died. And the Commonwealth looks at these wounds and says, there's nothing to see here. Why are we looking at this? This is,
She loses it. Yeah, she does. She does not like chalks.
you're following a red herring, basically. This is just a road rash. This means nothing. It has no impact on our case one way or the other. This is, according to the Commonwealth, simply a set of injuries that John O'Keefe suffered at the hands of being struck by a moving vehicle. Well, first, I would ask the common sense question, does this look like a road rash? I mean, the court's got years, decades of experience, life experience, and legal experience. Of course, this doesn't look like a road rash. It's not a road rash that any of us have ever seen. Or does it look more like claw marks and bite marks from an animal, which is exactly what they are? Second, if it was a road rash, where's the rest of the road rash? John O'Keefe had one set of injuries like this. Deep scratches, deep puncture wounds on his arm, on his right arm only, from mid-biceps.
Like the court clerk is not smart enough to turn the Zoom feed off. And like people are just sitting there. They could be swearing the whole time.
Mid-forearm and no other place. For instance, mid-biceps and mid-forearm that you might put in front of your face or your body if a large animal was attacking you.
I think it is.
Resulting in these
Yeah.
wounds. Why are the wounds confined just to his right arm? What about all the other pointy bits of a human body? If someone is rolled under a car or rolled
Right.
because in gravel
Right.
because of the car. What about the shoulders? What about the knees? What about the ankles?
Why are they
What
all
about
pointing in the
elbows?
same direction?
None of that exists. These are the only wounds. They're confined to his right arm, and they're deep scratch wounds, puncture wounds that are indicative of claw marks and bite marks from a large animal. And third, what about the Commonwealth's own expert? She has to
Commonwealth.
this, correct? She has to have said during the grand jury, I mean, this was a full-throated investigation surrounding the potential murder of a police officer. What does the Commonwealth's own expert say? First of all, she was never asked by the Commonwealth during the course of the grand jury
Commonwealth.
about the injuries. It took a grand juror actually asking the question of the witness, and she said, no, I cannot say that is a road rash. There's certainly not enough evidence to suggest that these wounds are consistent with a road rash. Well, she had to have at least talked about the fact that it was an animal, right? She had to.
Yeah, at this point, I don't think they really knew what they were up against yet. I think this is when they start to realize how bad it's going to be.
Well, had to have asked that question. She actually said nothing about whether or not that's consistent with an animal, because the Commonwealth very particularly did not ever pose that question. But we did. We hired one of the preeminent medical examiners in the country, a doctor by the name of Sheridan, Frank Sheridan. And he wasn't some deputy medical examiner. Dr. Frank Sheridan was the medical examiner for San
A
Bernardino.
crispy treat. We're going to listen to Lana after, and she says something so ridiculous, and we're going to address that thing that you just said.
County in California, with more than 12,000 autopsies under his belt, the supervising medical examiner for one of the largest counties in California, and he concluded to a scientific certainty that these wounds are from an animal attack. Period. Full stop. So, what do we know about animals and the Alberts? Which is exactly where Officer John O'Keefe was found dead. In February of 2017, we know that the Alberts had a dog.
The look on Eliza Little's face sometimes makes me crack up. She's funny.
Brian Albert with the dog, Chloe, in the foreground. By 2019, the Albert family had registered ownership of that German Shepherd. Moving on to 2022, in January of 2022, specifically January 29th, John O'Keefe suffers these animal puncture wounds, these animal scratches, these animal bite marks that are heretofore and up to this date, today, completely unexplained by the Commonwealth. By May of 2022, Karen Reed's defense team starts asking questions about this animal, about these injuries, about the dog, about what dog existed at the Alberts house. Where is the dog? We started inquiring pretty significantly. That same month, amazingly, the Alberts informed the Canton Animal Control that the dog was remarkably.
Yeah, Crispy, she says the most retarded thing I've ever heard in my life.
And to date,
We'll listen to
the
it.
Commonwealth has yet, as my colleague just mentioned, has yet to release the tissue samples to us for DNA testing to determine if there's evidence in these wounds of a canine attack, which we believe there will be. During that grand jury testimony, Brian Albert admitted to three things. Number one, he admitted that he owned a large German Shepherd. His words, not mine. A large German Shepherd. Number two, he admitted that the dog was at his home on the night John O'Keefe, early morning hours, John O'Keefe was killed on January 29th, 2022. And the dog, according to his own testimony, was inside the house and never in the front yard, which is where John O'Keefe's body was ultimately found. And the third thing that he admitted was that the dog was, quote, not great with strangers, end quote. That's a dog owner's euphemism for the dog bites, the dog attacks, the dog is mean or can be mean. So why wouldn't the Commonwealth ask about these injuries? Why wouldn't the Commonwealth inquire, as we have been inquiring, about the nature of these injuries and their significance in terms of John O'Keefe's death? It's because they know that the answer completely obliterates their case. Their theory of homicide.
Turtle Boy with the Turtle Boy tie on before he got the what do you call it? The
true answers to these questions. The answer exculpates Karen Reed, and the answer inculpates Brian Albert. That's because if that dog was inside the house that night, not on the front lawn, not in the front yard, but inside the house.
Stylist? Yeah, stylist.
Were suffered or sustained at the time John O'Keefe was killed, then that means John O'Keefe was inside the house when he was killed. And it also means that his body was moved.
Yeah, I just brain farted. I couldn't think of stylist.
We also know to be true, which is not one person that was in that house and ultimately exited that house from that party that night. Not one saw John O'Keefe's body laying in the cold in the front yard. And that's because he wasn't there yet. Multiple people walked out of the house, multiple people who would have no other reason, would have no reason to lie about that. A 200-pound man, 6'2", lying in the front yard on a light dusting of snow in dark clothing. Not one person saw him. But if John O'Keefe was beaten unconscious in, for instance, the basement of that house and later moved to the front yard after the guests left, there's your answer as to why no one saw him. And it also answers two other questions, which are looming in this case. Why would Brian Albert rip out the floor of his basement months after John O'Keefe?
You know what word came to me before stylist? Decorator. That's fucking crazy.
The second question, why would he sell his house? So in the months following John O'Keefe's death, the dog has been gotten rid of. Got rid of the evidence in the basement, got rid of the house, the crime scene itself. Your Honor, I would submit to the court that evidence is literally being destroyed right under our nose. It's been reported that the federal authorities have now gotten involved in the circumstances surrounding this case and have impaneled a federal grand jury to investigate some of these circumstances. But Karen Reed should not have to wait for the feds to figure out which heads should roll. I would implore the court, now is the time for the court to take some action and give us the tools, the defense, the tools that we need to fully investigate this case. We need these records to track down this German Shepherd, if it's still alive, which clearly is an open question. Our understanding is, at least up to this point, is that the dog was not only rehomed, but rehomed out of state, out of the jurisdiction of this court and out of the reach
Now,
of the defense.
we're about halfway through. I still haven't heard anything about the federal investigation yet, which Lana was
or at least that was the attempt.
referring
We
to.
need those records to find where that dog is. If the dog still exists, we need a saliva sample, we need a hair sample, we need something. And then we need the Commonwealth to give us the tissue samples that were taken at the time so that they can be compared. This is vital to the defense. We ask that the summonses at issue for the two entities that we've described, if those summonses issue, our request clearly meets the Lampron standards. Number one, it's relevant evidence. Number two, we definitely need a subpoena or a summons. They will not provide the information without.
I don't know. I can't remember whether or not they
defense.
did.
Number four, contrary to what the Commonwealth constantly says, oh, well, this is just fishing. I think we've established.
Oh,
this
she
is not
has
just
30 thumbnails that have him on.
fishing. We got a fish on the hook. We just need the court to help us reel it in. I will submit on further oral argument regarding the issues or the summonses surrounding the animal control and town clerk. If the court has any further questions about those, I'm happy to answer them. If not, I can certainly give the court a preview of the second Rule 17 motion, which deals with the phone records and the actual phone of Brian Albert. But I believe the court has indicated and we've suggested that an evidentiary hearing is in order.
Okay, so this was the first sign that these guys are fucked. Okay, listen to this.
I understand that the parties have agreed for an evidentiary hearing, and we rearranged our schedule a bit so that we could accommodate you.
That's perfect.
Okay.
The only thing I would say.
Oh, wait a minute. She didn't. Is it the next hearing? She's like, nope, no evidentiary hearing. We're not having one. Not in this case. She went totally against it, 100%.
In furtherance of that, very briefly, is the Commonwealth has suggested that Rule 17 is just sort of a regurgitation of something that we filed back in, I think it was September, that could not be further from the truth.
Crispy Treat, do you know what the date was? Because I'll correspond it with the date of this video and see if they knew it yet.
There is new information. There's dozens of pieces of new information that we have.
What I'm going to do because of that, let's let Mr. Lally respond to your remarks on the question first.
Thank you. Your Honor, first I would state it's an interesting sort of straw man argument as far as it being road rash, or that the Commonwealth has always maintained that it's road rash on his arm. No one has ever said that, but counsel for the defendant. As far as the injuries are concerned to Mr. O'Keefe's right arm and right forearm, they've always and consistently been described as abrasions caused by blunt force trauma, not road rash. I'm not really sure where the road rash comes from.
Well, what? Okay.
What I would submit.
Well, Lally,
with that is,
if it's not road rash, then what is it? I mean, he got hit by a car, right?
Whatever evidence the defendant claims, from the context of the rest of the evidence and the rest of the case, it's a little peculiar and conspicuously clear from the defendant's fact section that the damages to the right rear corner panel of the defendant's vehicle, embedded within the bumper to that vehicle, is pieces of cocktail glass. The victim, Mr. O'Keefe, is last observed on surveillance video, external
that's not true.
Establishment that he left just prior to going.
Wait, hold on. Embedded pieces in the bumper? No. That didn't happen.
Fairview, with a cocktail glass in his right hand. Same arm that's injured, the same type of glass that is then recovered from the bumper of the defendant's car. As the court is well aware, and I just stated for the records, under Rule 17, the defendant has the burden, or the moving party has the burden.
Yeah, I made the joke yesterday to Defense Diaries. I said I was once bitten by a Toyota, but the injuries were slightly less because Lexus's are a little bit better.
Establish that the documents are evidentiary relevant. Secondly, that they are not otherwise procurable reasonably in advance of trial.
Bumper sprinkles, yeah.
Prepare for trial without such production and inspection. And fourthly, that the application is made in good faith and is not intended as a general fishing expedition. The issue the Commonwealth takes with the defendant's request as it applies to these particular records is with number 1 and number 4. The Commonwealth would submit that the showing from the defendant is simply insufficient to establish any relevancy or evidentiary.
You got bumper sprinkles.
And then secondly, that this is the very epitome of a fishing expedition. The indication, even from the verbiage that's used by counsel in the motion, sort of sheds light as far as as I just stated, the sort of epitome of a fishing expedition. It's language such as "it could shed light," or "if true, this fact would undermine the prosecution's entire theory of the case." There have been a couple of theories that are stated within the context of counsel's motion. I can state for the record, those are not the Commonwealth's theories. No one ever said that the vehicle struck Mr. O'Keefe in the head and that's what caused the injuries. That's actually not at all what the grand jury testimony or the evidence has shown throughout the course of this investigation and throughout the course of this case. But those could and if true, those very words by definition.
I mean, it's not the Lexus's fault. It's the owners. You know, if they got scumbag owners, the Lexus has turned mean, you know?
The very nature of this particular request. The first issue,
they're actually very gentle,
within the motion is
but they have good owners.
Present. I'm not sure why so expansive a time frame is needed or necessary or relevant to anything that is a subject matter before the court. As counsel suggests, that photographs of Mr. O'Keefe's injuries suggest that he was severely beaten and left for dead, having sustained blunt force injuries to both sides of his face as well as to the back of his head, that there's evidence of defensive wounds, there's a cluster of deep scratches and puncture wounds to his upper arm and forearm, and then the defendant essentially asked the court to take the then inferential leap that these injuries, which are wholly inconsistent with the injuries noted by both the emergency medical personnel at Good Samaritan, when Mr. O'Keefe was taken immediately from the scene where his body was discovered, and from the medical examiner's finding in sworn testimony. So wholly inconsistent with those, that these are then take the inferential leap that these are consistent with bite marks or scratch marks from an animal, specifically a dog. In support of these assertions, as counsel stated, there's an affidavit from Dr. Frank Sheridan that the injuries are consistent with animal claw or scratch marks.
Right. Just bad owners. What happened?
Region, approximately 7 mm laceration, positive or surrounding soft tissue, swelling, positive breath sounds bilaterally, pulseless, positive superficial abrasions to the right forearm. Dr. Scortibello, the medical examiner in this case, who testified at length before the grand jury, described Mr. O'Keefe's right arm injuries as scratches caused by a blunt object. She described or noted that they appeared to be in a linear pattern. She detailed that she observed no signs of an altercation or fight from her thorough internal and external examination of Mr. O'Keefe. And lastly, she testified in great detail as to the swelling of his eyes being related to the fractures in the skull and how those manifested into the observable swelling and discoloration of his face. And essentially what she testified to was that there was a laceration on the right back.
No, Lally, shut the fuck up. Now he's trying to sound smart.
Cutter coup.
As Hank would say.
That there was a skull fracture in that immediate area, the right parietal area of the victim's skull. That then caused a swelling on the brain, which she observed, as well as Dr. Stonebridge observed during her neuropathology examination of Mr. O'Keefe's brain post-mortem. That then caused the swelling underneath of the skull, caused the radiating skull fractures that she observed in Mr. O'Keefe's skull throughout, and that the essentially nowhere else for the blood to go in the
Cutter coup.
then causes both of the eyes to swell. There was no evidence that Mr. O'Keefe was beaten and left for dead. There was no evidence of any defensive wounds. She was specifically asked those questions.
He did have defensive wounds.
As to those injuries and how they sustained. There's absolutely no evidence that Mr. O'Keefe ever entered the residence at Fairview on that particular evening. Counsel mischaracterizes some other statements made by a witness, Mr. Brian Nagel, who had come to pick up his sister at the residence. She came out, he observed that vehicle. He observes that vehicle from the entirety of the time that he's there. So he's pulling on to Fairview. Ms. Reed is coming on to Fairview in the opposite direction. The right blinker on and the left blinker on. The operator of the vehicle that Mr. Nagel is in then essentially flashes his lights and allows Ms. Reed to pull in first. So Mr. Nagel is there the entire time. That Ms. Reed pulls onto the
this is not good for you, Lally. I don't know how you're going.
Indicates that she initially pulls over to the right-hand side of the curb, then pulls the vehicle forward a little bit further. That's corroborated in testimony from a number of different people who were inside the house, as well as Mr. Nagel's sister, who then came out of the
house. That was the day,
talked to her brother
Crispy?
at the door of the truck that he was riding. Mr. Nagel further indicated that at no point did the brake lights come off, including the center top light of the SUV that he observed in front of the house. There were no footprints outside of the vehicle. He never saw anyone exit the vehicle. No one in the house reported.
He's sped up. He's sped up,
inside
Terry.
the house or seeing anyone exit the vehicle. And I'm a little confused just as far as counsel's statements, as far as the multiple people saw Mr. O'Keefe or never saw Mr. O'Keefe come into the house.
That's what it really sounds like.
Attacked by the dog. I'm just a little confused as far as are they in the conspiracy, or are these people sort of let out of the conspiracy because they say something that doesn't further that conspiracy? If they're all in the house and Mr. O'Keefe comes in the house and gets attacked by a dog and then gets dragged out to the bottom of the lawn and left there for dead, then why do they all testify that no one came in?
Because they're fucking lying. They don't want to go to jail, you asshole.
Witnesses. It's consistent with Mr. Nagel as well. It's consistent with the forensic evidence. It's consistent with every piece of evidence that has come to light at this point.
Why would they say that?
Further statements in regard to the
I don't know.
Some reported incidents several months after the death of Mr. O'Keefe. The counsel suggests reluctantly that the animal was violent and prone to violence from one incident that postdates this particular time frame of Mr. O'Keefe's death, and seems
Why would they say that? I mean, that's just crazy. I mean, they all said they didn't see him.
About how
so there you go.
From an incident that he has no information about, whether or not it involved another animal, whether or not it involved another human, whether or not it involved what exactly the incident occurred. This is simply not what Rule 17 is to be used for. That's what case law.
I hear that on rackets all the time, Nicola. It's fine. I'm fine. I don't give a shit.
Information, relevant evidentiary support, which is completely and utterly lacking in this particular motion, in this particular submission. So for those reasons, the Commonwealth would request that the motion be denied.
Okay. So the second Rule 17 motion, are we going forward on that and then having the hearing regarding the timing of the video? How are we going forward with this before I hear from you on the substance, Mr. Jackson? What is the next date for?
Yeah, I'm not really convinced at this point that somebody didn't have the hooks completely into Canone yet, because she seems to be on board with the evidentiary hearing, right? And she's like, oh, how do you want to handle this thing with the missing time? Like, she doesn't seem that terrible yet.
May 25th.
Right. What's it for? The evidentiary hearing?
Yes.
All right. So do you plan on arguing your Rule 17 motion today or that day? Not both?
That's it.
Okay.
I'd rather reserve and
that makes sense to me. That makes sense to me as well. So we're finished for today, unless there was any follow-up to Mr. Lally. I'm not going to hear a preview on the motion that we're going to hear on that day.
That's fine. I do have some points to make.
Okay, I'll hear you on that.
Thank you. With regard to
Miss Vicky, that's the last thing that Karen Reed texted to Higgins.
First of all, I think the Commonwealth misses the point. If there was a fight inside the house with the dog's owner, the dog would likely attack. That is the idea that is borne out by the evidence that we have. We know that he was beaten. We've got evidence that John O'Keefe was beaten, that he lay there unconscious. And we also have evidence that at the time he was beaten, facially, and
John's
blunt force was used against the back of his head, he was also attacked by an animal. Well, Brian Albert, who's a known fighter, owns a 90-pound German Shepherd that has since been gotten rid of and had a skin-piercing incident as the excuse for having gotten rid of him. So we know that the dog attacks, according to sort of uncontroverted evidence. We weren't saying, we don't suggest that the dog killed John O'Keefe. We're suggesting that the dog was
she
there
goes
when
from
John
this where she's talking about, okay, when do you want to schedule the, evidentiary hearing? How do you want to handle this? How do you want to do that? Until the next hearing, she's like, we're absolutely fucking not having an evidentiary. Like, everything switched.
O'Keefe died and also attacked John O'Keefe. That's the point. This is the first I've heard of the Commonwealth's new position after, 15, 16 months, that somehow John O'Keefe was stabbed or cut up with a broken cocktail glass, which would produce these injuries. That makes absolutely no
not
sense.
again.
It just doesn't pass the sniff test. These are not from a cocktail glass. Who did that to him? Is there a new theory that Karen Reed got out of the car, broke a cocktail glass?
This is the grifting portion of the presentation. We met the goal in the first hour. It's tremendous. Thank you very much. And see if we can get to maybe half a goal in the second hour. Thank you.
Yielded an edge of that cocktail glass cut up John's arm. Then John stood there while she jumps in the car, slams into reverse, then hits him with the car, with her taillight in the back of the head. It makes absolutely no sense. That is the Commonwealth grasping at straws. If it walks like a duck and talks like a duck, it's a duck. This looks like an animal attack because it is an animal attack. And it's at the same time, temporarily at the same time, that he was otherwise beaten and then ultimately left for dead. Interestingly,
Yeah, my cat is very expensive. He eats a lot of food. You see how fat he is?
It's interesting that the Commonwealth doesn't mention the basement in their arguments. I mentioned the basement because that's very likely exactly where John O'Keefe went once he walked into the house. There's no evidence that John O'Keefe walked into the house. The Commonwealth has evidence that John O'Keefe went to the house. They have it.
This woman reached out to me on X, and she's sending me this thing. I don't know how to explain it. Like you like connect it to the desk, and while I'm doing YouTube presentations, I could have Brando right here on like this little circular thing that is on like a stand. It's super cool. I think he'd love it and be right here. Yeah, she's sending it along. It's pretty cool.
Just sat on it for several years, or for several months, over a year. That the Apple Health data from John O'Keefe's own phone establishes that once he was at the location at 34 Fairview, he climbed 3 sets of stairs. The Albert House happens to be 3 floors, a basement, a middle floor, and an upstairs. His Apple Health data also shows that he took multiple steps after he left the car, after he left Karen Reed's vehicle. The multiple steps indicate that he was in the house. If, in fact, the Commonwealth were correct, and he stepped out of the car, was hit by the car, and fell down and died, if that's what their theory is, you would have no Apple Health data suggesting that he was climbing stairs and walking about. As if
Yeah. I mean, they had this all right, and then everything got all fucking. I mean, you know, experts like Whiffen coming in saying he drove up and down the road and registered flights of stairs on his phone and shit.
To unconsciousness. And then everybody in the house leaves, not having to go down to the basement. There's a door that services that basement that is closed. So there's no reason for people who are upstairs, either upstairs or on the main floor of the house, to even know that there had been a fight downstairs, or that John O'Keefe never made it out of the house alive or conscious. With regard to Ryan Nagel, the Commonwealth leaves out probably the most important part of his testimony. Ryan Nagel's testimony is that he arrived just after Karen Reed arrived. They arrived not at the exact same time. She turned down the road. Then he turned down the road. As he approached the road, as he approached the house, he then pulls to a stop. He had her car in his sights the entire time, just after she had already
An ice cube?
arrived.
I'll try
John
it.
to get out of the car and walk toward the front door. He said they observed that there was no taillight damage whatsoever. He later observed inside, either through a dome light or through other ambient light, that he could see inside the passenger compartment of her car, and that she sat there alone. And most important, he didn't see her hit anybody with her SUV. That's the most important part of Ryan Nagel's testimony. He didn't see her hit John with the car.
Thank you, Lady M.
If he was
100.
right behind her.
Thank you very much. I appreciate it.
And the Commonwealth has repeated what they've oft repeated several times, which is there was no sign at all.
You've done a lot tonight. Thank you. You don't have to.
If there's no sign of an altercation or fight, how can you turn around and say you got a cocktail glass in this? They can't talk out of both sides of their mouth. How did they reasonably ignore 2 black eyes, a laceration over his right eye, a laceration at his nose? He looked like he had gone 10 rounds with Mike Tyson, as my colleague has once analogized. Of course there's...
Yeah, Lana's out of her mind,
back of his
maybe.
hands, deeply bruised. Those are called defensive wounds. I don't care what their medical examiner called it. Anybody who's seen any sort of a fight, a street fight, knows that the back of the hands, the back of the arms get the brunt of the punches as you cover your face. Of course there were signs of a fight. Not just a fight, a brutal fight. And what does a dog do when its owner is in a fight? What does a German Shepherd do when its owner is in a fight? Reaches out and attacks and supports his owner. And what does a person do when a dog attacks? Usually puts his arm up, his dominant arm up, to protect himself. And that's where the lacerations, the bite marks, the claw marks appear on John O'Keefe's arm. This is not a fishing expedition. The
Miss
Commonwealth
Vicky May,
has
thank you so
unreasonable
much. I
expectation.
appreciate you.
they cite to words that we use
Thank
what
you so
the
much.
evidence might show, or what it could show, what it potentially will show, as a weapon to say, well, see, they don't know what the records are going to show. Well, if I knew what the records are going to show, I already have the records. I wouldn't need the court to ask
You
for
guys
it.
are the
Of
best.
course, I don't know everything that's in the records.
The
And
best
reason we asked,
community.
Your Honor, for 2015 is because we have evidence that in 2017, the dog looked full grown. So we wanted to go back and bracket the proper amount of time. If, say, the dog was a couple of years old at the time that photograph was taken in 2017, we want all the records associated with that dog, which means we bracketed our request. It's not overly burdensome. It's certainly not burdensome to the Canton Animal Control, and it's not burdensome to the Canton Town Clerk. And if the records don't exist, because they just don't, they're too old, then no harm, no foul. But that's why we bracketed our request to go back.
Thank
from
you, Be Happy.
2015 to present. And with that, Your Honor, I believe that we have made a good faith showing. We have met the standards of Lampron, all four standards of Lampron, and the summons it should issue. And also,
All right, anything else, Mr. Lally?
Just briefly, Your Honor, as it pertains to, Commonwealth would agree that tripping the cuts on Mr. O'Keefe's arm in their entirety with a cocktail blast would be somewhat ridiculous. That's not what I said. And that's not what I was attributing them to. And I think the court understood that, but just so counsel understands that as well. As it pertains to Mr. Nagel, what is in his testimony is that he had the vehicle. They arrived at the residence in tandem. The vehicle was there when Mr. Nagel left. So while he sees no one exit the vehicle, no one enter the house, and no one else sees anyone exit the vehicle or enter the house during that specific time frame, the defendant, and presumably Mr. O'Keefe, are still there and still in the vehicle at the time Mr. Nagel leaves the house. That was the point that I was making with that. As it pertains to the Apple Health data, and obviously we'll get into this a little bit more when it comes to that subsequent Rule 17 motion, the Apple Health data is the same Apple Health data that's being relied upon for the supposition of Mr. O'Keefe when inside the house. That same Apple Health data has, among other things, Mr. O'Keefe taking 46 steps and traveling a certain bit of distance around 11:56 a.m. on January 29th. The problem with that is that he was pronounced deceased at the Good Samaritan Medical Center some 4 hours prior to that. In addition to that, from the information as far as when that ascending or descending of stairs occurred between, I believe it's 12:21 and 12:24 a.m., there's a Waze search and location data for Mr. O'Keefe's phone. The Waze search is conducted, and the GPS location information from Mr. O'Keefe's phone shows him en route to the house and not arriving at the house until 12:24 a.m. So the information the counsel is relying on has him going up and down 3 flights of stairs before he's even at the house. So for those reasons, again, the Commonwealth would submit the defendant's not met its burden and ask that the motion be denied. Before we do conclude, I just did want to remind the court there are a couple of other issues that I need
Thank
to
you, Toy. You're the best.
The Commonwealth's motion to impound and the Commonwealth's motion for access to the defendant's phone.
Okay, I'll hear you.
So there were two motions to impound that the Commonwealth filed. One pertains to the grand jury transcripts and exhibits that I had attached as attachments or exhibits to the opposition to this specific motion, to really to
Okay,
both
and those are impounded by statute.
Right. The other motion to impound that I filed pertains to the attachments to the defendant's Rule 17 motion pertaining to Mr. Albert's cell phone and the call detail records of Ms. McCabe and Mr. Albert. Now, certainly the Commonwealth is not saying in any way, shape, or form that those items shouldn't be submitted. The defendant can submit whatever she wants, whatever counsel wants in support of that request for the court to review. But the manner in which the information is released, and specifically what I take issue with, and I'd be remiss if I didn't say this on behalf of the O'Keefe family.
I'm not sure I'm not sure they hear you.
Okay. In reference to the motion to impound the attachments to the defendant's Rule 17 motion for Mr. Albert's phone and the call detail records of Mr. Albert and Ms. McCabe, I'd be remiss if I didn't, on behalf of the O'Keefe family, as well as just what the statutory rules are, and specifically I'm talking about the Supreme Judicial Court, Rule 124, pertaining to protection of personal identifying information and publicly accessible court documents, which I would imagine that at least Mr. Unetti, even if Mr. Jackson and Ms. Little aren't familiar with, does provide rules as to how things are filed that are of that kind of sensitive nature and that kind of biographical information. And they're routinely filed with the court with a motion to impound or a motion to seal and not filed directly with the media. The issue being that there are photographs.
Thank you, officer. Yeah, I forget they're there sometimes.
At the Medical Center, as well as possibly some autopsy photos that should have been impounded. There are unredacted Canton Police Department reports, multiple copies. Again, not anything that Commonwealth takes any issue with the court reviewing, but as far as them being made public with those witnesses' names, dates of birth, social security information, addresses, phone numbers, things of the like that should be impounded pursuant to the statute as well. And in particular, I do take issue with that motion, specifically on page 11. There is a specific reference made to the name of the decedent's niece, which is strictly prohibited as far as being provided in a public document. So for those reasons, I would ask that the attachments to that motion, to whatever extent it can be at this point, given the public release of them, be impounded.
Mr. Unetti?
Your Honor, I believe that some of that information may be in the public domain already, so it may be that the cat is out of the bag with regard to some of it.
It is now, right?
I'm sorry?
It is out, the cat's out of the bag now.
Right, yes. So, I mean, we're agnostic on this motion to impound. We have access to it, the Commonwealth has access to it, and most importantly, the court has access to it.
All right, so by statute, everything that was raised by the Commonwealth was supposed
Sarah,
to be
whose name?
requested to be impounded at
Yannetti?
the time it was filed. So that was not done.
Are you talking about the motion that we filed with regard to the Albert phone motion?
Yes, the attachments. Mr. Lally just outlined it.
I don't think that there were any grand jury minutes attached to that motion.
No, that was a separate motion.
right.
Mr. Lally just filed on behalf of his motion.
Reddington?
When he was taking
I don't
issue
know.
with the defendant had filed.
Right. Okay. Yeah, again, we don't have an objection at this point.
All right, Mr. Clerk, those are both allowed. All right, is the hearing, those are both allowed by statute. So is this hearing over?
Your Honor, if I could just address, the Commonwealth had filed some time ago a proposed procedure regarding
Well,
communications.
thank you,
toward the
Ruth.
defendant's iPhone.
Appreciate you.
So we had addressed this briefly, I think, on the last court hearing date in February in relation to the defendant's phone. So the defendant's phone was seized lawfully from her pursuant to a search warrant. The information contained therein was then downloaded. Upon a cursory review of that information, there was an indication that there was some communication between Ms. Reed and Mr. Yannetti contained within
She,
the information within that.
Karen also lost a lot of weight between this and, I mean, she's got the health issues, right? In the second trial, she looked very thin in the second trial.
Phone. So obviously all examination of Ms. Reed's phone from the Commonwealth's perspective ceased at that time. And we had begun exploring and filing this motion. I had it in hand to file with the court on the last date. However, after several discussions with Mr. Yannetti and counsel for the defendant, I was then informed in court on the last date that the AFE or the independent sort of forensic examiner that would look at that phone was believed to have some sort of conflict. It was not acceptable to Mr. Yannetti. So there was a separate person who essentially runs the lab at the Attorney General's office, who I spoke to Mr. Yannetti about whether or not that person would be acceptable. He does have a conflict, just so the court is aware, as far as grew up in the same town as the victim and his siblings. But Mr. Yannetti indicated that he, at least verbally to me on that day, that he didn't see any issue with that conflict, as the person would just be assigning it to a couple different forensic examiners within his office. I then modified the motion to incorporate that subsequent AFE, sent a copy of the motion to counsel 6 weeks ago or so, and still have received no response. So what I'm looking for today is just action on that. The other thing that I would note for the court is that counsel then asked for a raw extraction, a copy of the material from the defendant's phone, which was then provided to counsel.
Why are my links showing up blue? I don't get it. I don't know what I'm doing wrong.
Commonwealth has not, because counsel has failed to respond to whether or not the AFE was reliable or not. And what I was referencing on the last court date is the court had indicated that if we were to come to some sort of agreement, the court could act on the papers and obviate the need to address it on this date. It hasn't happened. I would submit that the proposed protocol was more than reasonable, and I would ask that it be allowed by the court.
So, Mr. Yannetti?
Yes. I was the one to suggest that it be analyzed by the Attorney General's Office, Cyber Crimes Division. I thought that was clearly, we have no objection to that, but I'll announce it in open court. We have no objection to that. The motion for the protocol, procedure is agreed to.
And you're okay with the individual that was...
I have, I mean, it's crazy when you try to look up this pretrial stuff. It's almost impossible to look up.
I know who he is. I respect him. He revealed to me at the start that he has a personal conflict. I have no issue with him assigning it to somebody in his office.
Okay. So the motion is allowed by agreement?
That's fine.
Okay. Clerk? Motion is allowed by agreement.
Just one other thing. Mr. Lally had mentioned to me, and I don't know if he still intends to be heard on this, but there was an issue of exhaustive testing that I thought.
He argued that a while ago.
Okay. And was that acted upon by the court?
He said he was waiting to hear back from you where we stood on that.
Right. So with regard to that, Judge, we're all for exhaustive testing.
Thank you, Sarah.
We can have our expert.
Appreciate you.
Mr. Lally, would you explain to me? Would you say again what you explained to me?
Certainly. So there's a form that's provided by the lab that I then provide to counsel. In this case, in any case,
What am I talking about? The Venmo one I put in. It didn't turn blue. If it doesn't turn blue, you can't click on it. You have to.
Right into the lab will then contact their expert and schedule a time for the testing to be done.
Okay, we're happy to do that, but my understanding from Mr. Lally's earlier argument is that only applies to the hair that was found on the car. That was not part of any motion that we had today in terms of a motion to compel. What about the other evidence with regard to the tissue samples and everything else that we actually asked for in our motions today?
Is there exhaustive testing on any of those items, Mr. Lally?
Okay, fine. Yeah, so we'll sign regarding.
You go to Melanie's for pretrial stuff?
Okay, is that everything?
From Commonwealth.
Do
Yes,
that.
so, Judge, thank
All
you.
right, thank you. We'll see you on the 25th.
All right. Okay. So it wasn't really what I fucking thought it was. Actually, yeah. Masters SJC. If you hold on. Oh, fuck. You want to jump into it like that? Oh, this is 2 years ago. This is probably the first trial. This is jury selection. We're getting close. Selection delay. Opening statements. Can't PD 7. Can't. Okay, that's trial. That's trial. That's trial. That's trial. 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 Closing arguments is trial. Mistrial. That's all. Okay. I don't know. Let's try this one, I guess. God, that was loud, huh? Was that loud for you?
Norfolk County, and I think you guys, I did. Somebody asked me, is it really true you got stricken yesterday? And I think I did because, I don't curse on this channel, and I think it's just the way I.
She's so funny. I love her, man.
The way to pronounce it, right? So I think they will open before the start of their case. In this case, it's second-degree murder, which requires malice or intent. I don't want to give anybody any
I've been with Melody since like 3,000 subscribers.
Anybody who has any logical train of thought that looks at the evidence the way we have with an analytical mind is coming to the conclusion that there's no way that she hit him with her car. The evidence does not line up. It just doesn't. And it's not about accusing someone else of killing him.
This is pre-trial. I mean, we knew this shit.
She did not. And you don't need to be a rocket
pre-trial
to causing
trial one.
Injury or death. I will describe these crimes in detail at the end of the case when I
okay,
teach the
this is
law.
jury instructions.
Murder is the unlawful killing
so,
of a human being.
Look at the glare.
The defendant guilty of second-degree murder. The Commonwealth must prove beyond a reasonable doubt that.
Pretty wild just to see like.
This quote,
but without the benefit.
I mean, this ain't the one we're looking for. Obviously,
we know that in the subject of this case,
it's got to be before this.
For one outcome or another, even-handed. Steady.
Of the witness. So the witness.
Sources say the two had been in a relationship, and then.
Let's see what this is.
The original arraignment hearing, because I don't know how many of you have seen this. This is from January 2nd of 2022. This is the Stoughton District Court.
I remember this.
WC.
This is when Yannetti was in there, and this is what everybody says. They're like, oh, Yannetti says, it was probably just an accident. But people don't realize she had just retained him as a lawyer, and he's looking at this thing, and he's like, defense lawyers deal with a lot of guilty people. I mean, he didn't know anything about the case yet. You know what I mean? It's one thing to be told by, Karen Reed, I didn't do this, but when he goes up to argue bail in front of a judge, you need to take on a different tone. So everybody likes to bring that up.
In Boston, this was the live hearing.
You were standing on the roadway, looking at the property. The three females.
Right. Yeah. This is the original arraignment.
Lying on the ground as two of the females were performing CPR.
I don't think he regrets that statement at all. I mean, what would you say?
Ms. Jennifer McCabe and Ms. Carrie Roberts.
What if you had just been hired?
The victim to be pulled to the touch, no signs of breath, and returns to.
You know what I mean, like a day before, and like
Her name has arrived on scene. Over first aid. paramedics then transported the victim to the Good Samaritan Hospital in Brockton, where he was determined to be deceased several
Yeah,
hours.
no, Melanie's awesome. I love her.
Detectives from the Canton Police arrived on scene moments after the 911 call. They began to search.
I've known her for a while. We're both deadheads, so.
Snowbanks for any evidence, at which point they discovered a broken cocktail style glass.
Okay, I'm going to stop right there. He says a broken cocktail style glass. We have been over the original Canton police reports, and in the Canton police reports, the evidence logged in was a broken drinking glass. The fact that he is changing the terminology during this arraignment makes you go,
On scene moments after the 911 call, they began to search within the snowbanks for any evidence, at which point they discovered a broken cocktail style glass.
Okay, I'm going to stop right there.
Listen, if anybody can find this gag order hearing or the motion to recuse Canone, could you send it to me? Like, it's so hard to find these pretrial
He
hearings.
says a broken cocktail style glass. We have been over the original Canton. 13th
Go
scene again, sometime around or after 6.
Let's keep going here. I'm looking for a pointed thing.
Now they're going to find the taillight pieces. So what they want you to believe, my friends, is that the Canton PD is so incompetent. They are so incompetent that despite the fact that they found clear pieces of drinking glass and 6 drops of blood, they did not see a black sneaker or red taillight pieces.
The clear was right about the shoe.
Not submitting during discovery is allowed to come in during trial. We love Melanie. It's a great question. And it's going to be within the judge's discretion. And as we know,
Yeah, Crispy, Miss Scarlett's great.
Gone back and looked at the hearings.
I like her a lot.
I started covering this case in January. It's at the judge's discretion. So they've been fighting to get the Bodie DNA results the defense has for many, many, many months, if not a year or more. And that is just being submitted now. So the judge has a lot of discretion with regard to what evidence comes in, and she hasn't ruled on some of this stuff yet. So I think we're going to
Why
find out.
is the there's no chat available
Karen
or
was sectioned on the
anything?
29th. How did her car get to her parents' house? Great question. Apparently they brought her in to section her, but they let her out. And I believe she did drive her car to Dighton. If anybody has differing information, please let me know. This is a collaborative channel, and I know so many of you know the players involved here. You know more than
Oh, look at that. The chat from that long ago.
No, but my understanding is she was let go. They did not feel the need to keep
Who's
her on
in here? I'm
72-hour
definitely in
I
here
think they call
somewhere.
it a Section 12 in Massachusetts. And they took her there. They took her blood, and then they let her go. Hi, Heather. I'm behind. But what type of testing did they claim to do? I never heard them mention GCMS. I'll look for that stuff as a former kind of. You know what they did? They took her ethanol level from the CBC. I'm assuming it was a CBC that they did. They took her ethanol level, and they're trying to extrapolate that back.
Extrapolations, bullshit.
And they're trying to extrapolate that back. And according to their calculations, and if you're a chemist, you're going to be interested in this. According to their calculations, according to that.
Oh, a lot of people in there you don't see anymore, but some familiar
They were
names.
claiming that when they did draw her blood, her blood alcohol level was 0.08, and when they extrapolated it back to something like 12:45 a.m., they're saying it was between 0.13 and 0.29. I think that's a little bit of a range there. 0.13 and 0.29. I find that to be a incredibly large swing. And if you're a chemist, please chime back in and let me know whether I'm
No, Melanie was doing it before that.
Oh, I think this is a good time to hear a word from our sponsor. For those of you who don't know, AT&T Wireless had a massive data breach a couple of months ago when they told everyone that their service was out for the day, and they were doing a software update, and they gave everyone a $5 credit on their bill, and you may have been affected by that. But what really had happened is that 74 million customers of AT&T Wireless, your social security numbers were leaked to the dark web. Not just your socials, but your name, address, date of birth. Not just current customers, but customers who had been customers since before 2019. And my sponsor has been my sponsor before that story broke, but I think it's timely. So take a listen to a message from our sponsor, Aura. Did you know that the odds of falling victim to online crime are 1 in 4? Online crime is soaring. It's time to get smart about online safety. That's why I've been using Aura, the sponsor of today's video. Aura provides everything you need to
She had
protect your
sponsors
privacy,
back
your
then.
identity.
She's making bank now. She doesn't need that shit.
Because the police had come and they had taken her phone and they had taken her car. She knew that they were considering her a suspect, rightly or wrongly. And what did she do? They arrested her at the very address that I included in my letter to the Commonwealth, which the Commonwealth ignored. This is relevant, I would assert, Judge, regarding whether she is a flight risk. I think that it doesn't really pass the straight face test. She's not going anywhere. She didn't go anywhere. I frankly don't think they've overcome the presumption of personal recognizance in this case. With regard to the facts of the case, Judge, I've read the affidavit that the prosecution has now read. Manslaughter is a tremendous reach in this case. I don't see any criminal intent that would justify manslaughter in that affidavit. And there's a reason for that, because there was no criminal intent. This was not some random stranger. This was my client's boyfriend, somebody with whom she was in love, somebody with whom she essentially lived with. And
Yeah, Sarah, I got that. That's Sleuthie's spreadsheet, right? I don't think the pre-trial things are in there though.
At 4:30 in the morning, my client is placing multiple.
Oh, it'll give you the date. Okay.
To her boyfriend, wondering where he is, why he hasn't come home.
Well, I think I can get the date. It just whenever you search for it, it just never comes up.
Had to go to bed without saying goodnight to him. She had no idea that he was deceased or that anything had happened.
Okay, let's. I don't want to get too far. I don't know. I mean, I could watch Melanie all night, but that's not kind of what we were doing.
Think somebody threw the glass at him?
I mean, it's much more pleasant.
Think that he broke the glass and then cut him with the glass? That's interesting.
You know, all of that,
You
but
guys
we
love
gotta.
these way wicked accent.
This lunatic is what we were kind of doing to begin with.
Charlie Lynn, thanks for-
She's gonna say some wild shit.
Is to lie. And that's the position that they took. And I want to know why. Because what it ends up doing is
Hold on. I'm gonna go.
Karen Reed's supporters cheered as she walked into the courtroom today. She is accused of killing her boyfriend, Boston police officer John O'Keefe. But Reed says she's innocent and that accusing her is all part of the cover-up. WBZ's Tammy
continues to capture the public safety while dropping him off a step away from the trial and lashed out.
Of 2023. And at the end,
Okay,
it's important to understand. So it's just a timeline. In May of 2023, and at the end of April of 2023, at the time, in real time, we had no idea, not a single clue, that
She doesn't
in
give us
actuality,
fucking
Boy
actual
is
date.
communicating with the defense team. In fact, they went out of their way to tell us all that they were not communicating. Okay. And at the end of May of 2023, that is when the defense launched the Free Karen Reed.
Why can I?
Donation fund. We're going to raise funds, and it's going to be a crowd funded pot of money.
Oh my God, how
that is
fucking
basically
aggravating.
You're fighting for your rights as well. Karen Reed was framed. This is how this played out, right? And in fact, it was not only did they use Turtle Boy, which we're gonna get into here, that big old poster that was.
She doesn't. She doesn't. No, she doesn't fucking.
Who's that communicating with? How do we know that that's even Sean McCabe's social media? Because we've witnessed Turtle Boy make up.
All right. She doesn't say the date.
I'm going to tell you guys a little secret. Okay.
There are links in the chat you might want to try.
The Karen Reed case doesn't change a very important fact, which is that
the
defense team goes out and they get experts and they pay them, right?
Okay, I can't tell what they.
And they pay them for what?
Toy has a link.
You don't ever have to turn over to the prosecution that you went through 7 fucking.
Crispy has a link.
Witnesses to finally get to the one that's going to say what the fuck you want.
Are one of those what we're looking for, or?
Why did everyone always assume that John O'Keefe was standing straight up and straight down when he was hit? How dumb.
Oh, wait a minute. Wait, no. We're going to come back to this. That's too rich. That is too good for words. Is one of those one of the links we're looking for here? Copy and paste your link. How far back is it? I don't know. Crispy treat, what is that? Should I click that link or is that something else? I don't. When you're in the StreamYard, if you go to click or you can't like copy and paste it, because once you click on it, it goes blue and then it goes up on the screen. How can you possibly fucking... You can't. Wow. Okay. Okay, 1 minute. Okay. You might be onto something. Let's see this.
The federal investigation. We've been saying since September 16th, 2022,
I think you might have got it
in
there.
lengthy motions that we filed before this court and filed with the
I think you might have got it. Crispy. 1 second.
Commonwealth. There is a conflict.
I think this is it.
And
Thank you, Crispy.
Also, I keep coming back to the letter that was written to me on February 26th from the Deputy U.S. Attorney, who says, "We expect, of course, that the parties will disclose orally the materials in court only as necessary to further the proceedings." So I've read everything. I'm going to give each side 10 minutes, and we're going to start with the motion to dismiss. So, Mr. Jackson, I'll hear you. I think it would be particularly helpful if you were to focus on the exact prejudice to the defendant and how this all goes to the core of the Odell motion. And as you know, that's an awfully high bar. So,
fuck off.
Your Honor, I will try to edit my comments to stay within the 10-minute mark. It's very difficult to do that. I did not know that we were going to be
10 minutes.
Time constraints. As a matter of fact, I thought that the court said the last time we were in court, we had basically your words.
yeah, all day. But that was when we had all the motions. But it's just these two motions
Right,
today.
but they're big.
They're big.
Consistent with.
Why don't you go ahead and start? If you need additional time, tell
And
me.
she's an instant bitch now. I mean, as opposed to that hearing we just watched.
Again, I'm mindful of what the U.S. Attorney said to me in that letter.
And I am as well. And that mindfulness suggests that my comments will be directed to that which is necessary to further the proceedings.
Okay.
Which means that
right ahead.
I'll start with the basic rule of Odell. We start with the postulate that any distortion of the evidence.
She already hates him.
Any distortion of the evidence during the
She
course
hates him at
of
this
a grand
point.
jury proceeding impairs
He hated him
the
overnight.
Indictment, if there is an indictment, and pursuant to Odell, that requires dismissal. In this particular case, there were myriad examples, which I'll edit. I was going to go through several, but I'll just touch on them very quickly.
Your memo, I have to say, your memo is very thorough and very helpful to me. because
Instant
you outlined
cunt, just
everything
add water.
Thank you. The first point I want to
Or
discuss
White
is
Claw or whatever.
What we believe is the failure to disclose Sergeant Michael Lank's personal lifelong relationship with some of the individuals, specifically the individual Chris Albert. There was a comment or an incident, I should say, that we referred to in our moving papers that dealt with Chris Albert and Sergeant Lank years ago. They had a long-standing, years-long relationship, and I'll close this loop in just a second, but if you'll allow me, that relationship goes all the way back to 2002 at least. There was an incident in which Sergeant Lank...
Like, he's not a dickhead. You know what I mean? He's confident. He knows what he's doing, but he's not a fucking asshole. There's a lot of asshole defense attorneys.
Stumbles out, announces to the participants in this fight that he was quote unquote deputizing himself, and ultimately came to Chris Albert's aid. That was with the specific intent to assist an Albert in getting out of a legal jam all the way back to 2002. The reason I bring that up, and by the way, both of the individuals involved, not Sergeant Lank, both of the other individuals involved were ultimately arrested by Sergeant Lank. That case went to trial. And both of the individuals were found not guilty.
Yeah, Nathan's face always cracked me up. He was go like, "Are you fucking serious?"
To the degree that the Canton police officers had to pull him off of the individual.
So this is in your memo, and it also is exhibits C through E
That's
attached
right.
to your memo.
And the reason this comes to a head, and the conflict of interest comes
She
to
just
a head
hates him because he's
Michael
fucking.
Lank ultimately was the first
He's
person
high
to
profile
to
and he's
Brian Albert's
effective
house.
and he
During the
wins.
course of the grand jury, nobody elicited
She can't
information from
fuck
Michael
with
Lank
him.
that he had a close personal relationship with the Alberts.
I
that he
mean,
had
well, she
in
can
the
fuck
past
with him because
come to
she's
the
the
Alberts
judge,
family.
but
And yet he was the first person that came into the house. Even the grand jurors
You know,
were stunned by this. And
on
asked
an
the
intelligence
grand jurors, asked Michael
level, I
Lank
mean, she's
and
got
asked the
nothing.
Commonwealth, or through the Commonwealth of the witness, why didn't Brian Albert ever even come out of the house? And I think we have the answer. And the answer is because the Albert, specifically Brian Albert, was waiting on a friendly.
Well, he's
That
not a
was
Canton
Michael
cop, you know what I
That
mean?
was withheld from the grand
He's a
jury.
Boston
Sergeant
cop,
Lank is a
so
longtime child
he really
friend of the
couldn't.
Alberts.
You know, what do you want him to do? Go
Purpose
down
for
his
the
underwear?
Alberts because of those personal and familial relationships that the Alberts have with Canton Police Department. And Sergeant Lank has a history of using his position as a police officer to shield the Alberts from criminal liability. That was never brought out. That's the kind of distortion that Odell talks about. Another broad example or a broad category that I want to discuss briefly.
I'd have resting bitch face if I was her. I'd have resting, I'm gonna fucking
Withheld from
kill
the
you
grand jury
face.
clear and even more egregious conflicts of interest as they pertain to Michael Proctor.
I'm surprised she held it
Where
together
this
as much as she
irremediable
did.
conflict that Canton Police Department had and that he should have had with the Alberts. So what does he do? He calls in Massachusetts State Police. And who do they send but Michael Proctor? And that's like jumping from the frying pan into the fire. That's the same Michael Proctor who's also years long close family friends with the Alberts. The Proctors have called the Alberts their, quote, second family. And to that point, now we have benefit of some hindsight, and that's the federal investigation. We've been saying since September 16th, 2022, in
So
lengthy
at this
motions
point,
before this
they know about the investigation. Let's hear what they say because we heard what Lana said, right?
court and filed with the Commonwealth. There is a conflict. You're not investigating the conflict. That conflict was never described to the grand jurors, and we've been rebuffed at every single turn. Newly uncovered text messages, but from the feds, revealed that on January 19th, 2022, think about that date, that's 10 days before the incident. January 19th, 2022, Michael Proctor texted his own family members discussing the specifics of having Julie Albert babysit for his toddler child. We should all let that sink in for a second.
So yeah, I understand that.
There is a level of closeness that cannot be overstated. Michael Proctor is so connected to the Alberts that he was entrusting them or willing to entrust the Alberts to be caregivers for his toddler child. And it's not lost on anybody in this courtroom that for 2 years, the Commonwealth has been denying it and still denies it in their opposition paperwork. They still say, well, there's nothing to see here. It's Michael Proctor's sister who really is friends with Julie Albert, and that, that's not a big deal. Everybody look.
But remember,
as a matter of fact, Ms.
Lana
McDonald
is saying
her opposition. Trooper Proctor's supposed close and personal
and not that it
relationship with the
even
Alberts
would
is
really matter
entirely
that
unfounded and a desperate
they
creation
built like a
of a
ruse.
desperate creation of ours. Which she says
They said they heard about the federal investigation from Turtle Boy
investigation. And the Commonwealth
and
has
then
to self-admit
lied
in
to
your
her
position
about the
about
gag
to eat some
order.
very distasteful words because we didn't create anything.
On
February 1st,
basically,
2022,
they
3 days after
had
the
him
child
write
was
a blog.
There was another
They
text
said he
message,
got the
and this one,
information
Michael
from the
Proctor's
blog,
sister
but they know they
texts Michael
didn't,
Proctor very
and they
specifically
completely
and writes,
lied
quote, just saw
to
Julie, and Julie
avoid
said
a
when all
gag
this is
order.
over,
That's what she was
wants to
saying.
give you,
So,
Michael Proctor, a thank you gift.
I mean, this
Michael
bitch
Proctor
lies
doesn't
so much,
respond
it's hard to
with,
keep
That's
track.
inappropriate. These are witnesses. These are potential suspects. Please tell her don't ever do that again. Don't ever suggest an exchange of gifts again. That would be inappropriate. I'm going to go write a report. I'm going to turn it over to Mr. Lally, and Mr. Lally's going to turn that information over to the defense and to the court. No, that's what he should have done. What he did do is he responded, get Elizabeth one, his wife. In other words, get the gift from my wife.
This is when all I'm pretty sure they had the Tui dump at this point, right? They've had to. They would have had to because they had all the ammo at this point, I believe.
Now we have the lead investigator from Massachusetts State Police literally discussing the exchange of gifts between the Albert family on the one hand and the Proctor family on the other hand as a thank you, their words, for helping the Alberts out of a jam. And if you looked up quid pro quo in the dictionary, you would find this set of text messages. 2 years later, to the day, on February.
You guys, I'll be right back.
Now let's fast forward 2 years later. Now Michael Proctor finds himself on the witness stand in front of a federal grand jury, which we just found out about. That grand jury was tasked with a singular commission, and that was investigating crimes of public corruption by law enforcement in relation to this case. And during that testimony, he was confronted with these and myriad other examples of evidence of his close ties to the Albert family. And he admitted to an AUSA under very intense questioning that not only does he know the Alberts, and does he socialize with them, does he drink with them, does he go to pool parties with them, but he told his partner, Yuri Butnik, all of this before Yuri Butnik testified at the grand jury and before he and Butnik actually interviewed Chris Albert. Why does that mean something? Why does that mean something to the court and to this argument? Because when Yuri Butnik testified before the state court grand jury, he testified that, quote, following formal introductions, end quote, Julie Albert and Chris Albert provided their phone numbers. Following formal introductions. That was a clear deceit on the grand jurors. Yuri Butnik knew, as did Michael Proctor, they didn't need formal introductions. Michael Proctor was considering having Julie Albert babysit his kid 10 days ago. Actually, at that time, 13 days ago. That left the grand jury with the intentional false impression that these people literally do not know each other. They've never been in contact. They're complete strangers. That was a lie. That was a concerted effort to hide that relationship and to hide the conflict of interest. And the grand jurors were fooled. They were left with the impression, Michael Proctor, Yuri Butnik, they don't know these folks. They're completely neutral, independent investigators, and nothing could be further from the truth. And the revelation of this evidence culminated in front of that same grand jury on February 1st, 2024. Under additional intense questioning by the Assistant United States Attorney, Proctor was caught in his own web of deceit and testified as follows, quote, so this is the AUSA talking, or asking the question. So obviously we're asking questions about your relationship with Julie Albert, with Chris Albert, and with Colin Albert. Do you understand that? Answer, yes, sir. Question, and you're saying that you're minimizing, quote, minimizing your relationship to the grand jury, correct? Answer, yes. He finally, under the scrutiny of a federal grand jury, admitted that he had been lying about his relationship to the Alberts, which means he lied to the grand jury, which means that evidence was distorted in front of the grand jury. And that is the burden that Odell requires.
All right, so your time is up, which includes me interjecting. Do you want 5 more minutes?
If I could implore the court.
I'd like you to sort of get to the questions I asked as well. All right, I know you're reciting the evidence that I've read, but so I'll give you 5 more minutes. Go ahead.
Thank you. I want to shift gears to another example or another series of examples of evidence that was distorted before the grand jury. And that deals with the use of, or the insinuation of Kevin Albert, yet another Albert, at the behest of Michael Proctor. Kevin Albert is a sworn Canton police officer. On day one, the Canton Police Department was completely recused off the case, in no small part because of Kevin Albert and the fact that John O'Keefe's body was found on Kevin Albert's brother's lawn. Yet the evidence that has been disclosed by the federal investigation, which we were not privy to, is that Michael Proctor actually utilized Kevin Albert's services to coordinate with the very witnesses who should have been potentially suspects and certainly should not have been subject to coordination by an Albert, when that's the very person on whose lawn John O'Keefe, or his brother's lawn, John O'Keefe was found. I want to turn to at least one more situation in my remaining minute or so, given the fact that this is curtailed. And this is not in our papers, but obviously it's a complete and probably the most obvious distortion of the facts. The Commonwealth suppressed one of the most obvious pieces of exculpatory evidence in the entire case, and that was a piece of evidence that they know torpedoes their entire case and their theory of this case, and that's Jennifer McCabe's Google search at 2:27 a.m., how long to die in cold. They had her phone at the time of the grand jury. They had her complete extraction of that phone at the time of the grand jury. They had a Celebrite report, Your Honor, at the time of the grand jury, and yet they did not present this evidence. They claimed, oh, well, we didn't have the right version of the Celebrite software. That's on them. That's not our fault. Certainly not Ms. Reed's fault. That's their fault. Get the right software. If you're going to bring this case, do it the right way. They say their argument is, well, we just didn't have the right software, so we didn't have the information. That's not true. They did have the information. It was sitting in her phone. They just didn't do their job and extract it. And should the Commonwealth once again stand up in some sort of desperate pitch to dispute that time and this critical evidence, the court should note the following. Not only does the Celebrite report confirm the search and the time of that search, not only do our experts confirm the search and the time of that search, but now a Quantico-trained special agent with the FBI's Regional Computer Forensic Lab, in other words, the United States Federal Bureau of Investigation, also specifically confirms that search was made on Jennifer McCabe's phone, and it was made on or before 2:27 and 40 seconds a.m. on January 29th, 2022. That fact, Your Honor, is no longer open for debate. And none of that was presented before the grand jury. I'll conclude by saying any one of these examples, and I didn't touch on all of them, but any one of these examples, the gift giving, the babysitting, the telephone extraction, the Google search at 2:27 in the morning, all of these, any one of these would be enough to dismiss the charges as they sit here today. But the cumulative effect of this deception and all of it, this distortion from the grand jury, is too much for the court to ignore. The simple fact, Your Honor, is the presentation before by the Commonwealth before the grand jury in the state court action, it just wasn't fair. That's the easiest way to say it. It just didn't give Ms. Reed a fair shot. It just didn't. That presentation was packed with lies, known lies by the investigators, and the omissions and the manipulations and deceit by the very people that are supposed to be the ones that we in the community can trust. The ones that we're supposed to protect our interests. And the law does not allow this sort of conduct to go unchecked. When the remedy, when this sort of travesty of justice occurs, is established by this state's Supreme Judicial Court, and that is dismissal of the indictment in its entirety. And it is not enough. And I'll be surprised if I don't hear it today. But something suggests, based on the moving papers that we just got from Ms. McLaughlin and Mr. Lally, are, well, Your Honor, we didn't know. We didn't know about the text messages. We didn't know about Proctor. We didn't know about Lank. All that stuff was revealed through the federal grand jury. It doesn't matter that Ms. McLaughlin...
I like Unetti better as well,
I claim ignorance.
Nicola.
It's enough that an arm of their institution, law enforcement, they knew. And that was their job to tell the truth. That was their job not to fool or distort the Commonwealth. I'm sorry, the grand jurors. With that, Your Honor, thank you for the time, and I'll submit.
All right, thank you. Mr. Lally, we're going to start with 10 minutes. If you need more, you need to tell me.
Sure.
And thank you, Your Honor. No, I think 10 minutes should be fine. I know the court is...
He doesn't really like grocery bags.
Taking detail to go through all the material that's submitted, so I'll be as brief as I can.
He's just starting to play with toys.
Essentially, the defendant, as the court is aware, doesn't challenge the grand jury presentation on the McCarthy grounds or probable cause standard. Defendant motions challenges under Odell.
He
essentially states dismissal of an indictment on...
He's still a little skitterish even now, like if I'm walking from one room to the other and just like I walk past him, like sometimes he'll sit there, but sometimes he'll skedaddle like and he'll like look at me like he had a traumatic life, definitely. So he's coming along though, beautifully.
On impairment of the grand jury proceedings requires proof of 3 elements, as the court is well aware. One, that the Commonwealth knowingly or recklessly presented false or deceptive evidence to the grand jury. Secondly, that the evidence was presented for the purpose of...
I think he'll come around.
And 3, that the evidence probably influenced the grand jury's decision to indict. None of which I would submit the defendant has met the burden with reference to any of those 3 elements.
Yeah.
Just addressing...
He's all scarred up. I mean,
themes of the defendant's
he definitely had a very, very rough go.
As he just stated, the testimony of Canton Police Sergeant Lank and his testimony attributing statements to the defendant that were made in the aftermath of Mr. O'Keefe's body being discovered in a...
Yeah, I mean, from
Sergeant Lank's relationship with the Albert family.
Where he was, like, when I got him, I mean, it's like, it's night and day. And I got him, like the second week of March. So it hasn't been that long. He's come so far already.
Trooper Proctor's purported false and deceptive statements throughout the course of his testimony, and the Commonwealth's failure to elicit a purported inconsistent statement of Christopher Albert, and the Commonwealth's failure to impeach Julie Albert's testimony. Your Honor, simply put, none of these issues or stated malfeasance actually occurred before this grand jury. As it relates to Sergeant Lank, I mean, we're talking about what the defendant submits as an attachment is an incident from almost 20 years ago, which doesn't involve anyone who was at the house at 34 Fairview Road on the night when Mr. O'Keefe died. The statements that Sergeant Lank is attributing to the defendant were not only testified to by Sergeant Lank as in their testimony.
I spend a lot of time with him. Like he's spend a lot of time with him, and give him a lot of attention.
testified not in a deceptive manner. They're testified to by Sergeant Lank in the sense of he indicated he spoke to officers who had preceded his arrival. All of those officers also testified before the grand jury. All of those members who received statements from the defendant essentially indicating that she did it. That doesn't just come from one source. That comes from at least 5 different witnesses, 3 of them paramedics with a Canton Fire Department. Counsel posits the question of why didn't Brian Albert come out of the house? No one did. Not only out of that house, but any house. It's clearly visible in the grand jury exhibits. You have the cruiser camera footage from Officer Saraf, as far as no one else in the neighborhood coming out of the house, as well as testimony from a number of different witnesses that were there and present on that morning in the dark, in the blizzard.
Here he is now. He came in here to stare at me.
Counsel wants to say that the Commonwealth is asking the court or everybody to sort of look the other way when it comes to these things. What I would submit is that's exactly what the defendant is doing. Look the other way, defense by obfuscation. It's essentially, it's a 3-card money trick, card trick on the corner on the side.
3-card money.
Look at all of this. Look at this relationship. Look at that relationship. Conflating these relationships, sort of the distortion that I would say between what exists in social media realm and what exists in reality. That if you know someone, that automatically means that you're best friends with them, every single one of their siblings, every single person that they've ever met or socialized with.
He
transforms into a long-standing.
He's here. He wants to be picked up. He wants to sleep. He wants to sleep on me. He's here. But by the way, I mean, I told you guys if we met goals, I mean, I was going to do something. I'll try to do that. Here, let's do this real quick, huh? Which one is this? Okay, we did that one. We did that one. Did that one. Okay, so this is a toy. Causey has the fart files smelling up. I mean, piling up. TFF Causey needed that so much. Thank you, Toy. I appreciate it very much. You guys are awesome. When I did a beach live the other day, I had a goal set up for 5 5 things, and Danny came in and knocked all 4 of them down, and one person did one other. You know what I mean? So you guys are awesome. You guys get it. Chastity. One thing. She can't get one thing right. Yeah. There you go. That about sums it up. Thank you very much. Birdman, 1980. Causey, the Charles. Oh, yeah. The Charles call the other night. Called Will a couple months ago. Yep. Brought him there, he claimed. Not sure if it's I don't know. I think some of it's a bit. He tries to be cute, and it just kind of doesn't work. Yeah, he's a weirdo. He got all mad and got pissy and hung up the other night. Oh, thank you, lady. Again, thank you very much. I appreciate you. And then she goes again. Thank you, lady. Wow, she's trying to help me meet goals here. Thank you so much. It's so nice. And then she is again. Thank you. Awesome. Miss Vicky May, $4.99. Thank you. It's a super sticker, I think. Toy again with $9.99. Wow. You guys are incredible. Ruth, $2.79. Thank you, Ruth. Causey the artist, Sarah. Yeah. I'd like to get back to some meme making soon. I need some ideas. You guys got to give me some ideas. Lana is a trash bag. It says tattoo 9419. Thank you so much. You're absolutely correct. Allie in Texas, $1.99. Thank you so much. Appreciate you. And here we go. Officer Twat Katie, $20. Thank you so much. I appreciate you. Is that correct? Am I reading that? Yeah. Officer Twat. Oh, is that the lady from the one Jimmy does the impression of? Katie from the Kelsey case? Oh yeah, hey honey. Yeah, that I think that's who that is. Anyways, thank you all so much. All right, it's up to you. You guys want me to try some kitty content, or you want to keep going with this? Or do you want to save the kitty content for the very end? I'm fine with it either way. Let's lower. Okay. All right. Let me figure out how I'm gonna do this. Give me 1 minute, okay? Oh, hold on. All right. Okay, so the iPad thing is not working. Yeah, not working. Not working. Okay. It's not working again. So we will go like this. We'll go like, we will go like this. Give me 1 minute here. Okay. All right. Give me 1 minute. I got to set this up. All right. So what I'm going to do is give him some catnip here. Hold on. So what I'm going to do is give him some catnip here. Hold on. So what I'm going to do is give him some catnip here. So what I'm going to do is give him some catnip. Why is it echoing like that? What is going on? Hold on. We got problems. Why is it? We got problems. If I'm speaking to you guys right now, is it echoing? No echo right now? Okay, cool. All right, 1 minute. Okay, hold on. Okay, hold on. Get some light in here. Okay. Hopefully I can do this correctly. It's hard to know where to put the camera. 1 minute. Good boy. There he comes. Look at that. The cabinet, dude. You don't even see it, dude. Over here, look at. Look at. No, over here. Over there, buddy. You don't even see it. Here. Come here. Oh, yeah. Go ahead. It's okay. Don't wake the neighbors up. Go ahead, boy. Shit, hold on a minute. Full screen, idiot. Go ahead, boy. Not into it tonight? Go ahead. He's not into it tonight. What's the matter, baby? All right, hold on. Wish I could place this thing. Shit, it's not gonna work. Maybe I didn't give you enough, boy. Maybe you need more. Don't OD on me. Shit, you can't even see him. It's okay, buddy. Go ahead. You can go have fun. Go ahead, boy. Aw. You just want to be pet. You should. I just gave you a bunch of catnip and you still just want to be pet. You want some of your drugs, buddy? You don't have to be guilty about it. Go ahead. Go ahead, boy. No? cute, man. Come on. Come on. Come over here. Come on, go ahead. Go ahead, have some fun. Get high, man. Go ahead. You don't even care, do you? You just want me to pay you. That's all you want. All right, guys. I mean, that's all he wants, man. That's all he wants. Anyways, if the iPad worked, this would be a lot easier. But it's just not. It's not cooperating with me. Okay, headphones are back on. This is a whole production here. All right. Pull the comments back up. Yeah, he is a little he is a little chubster. He is getting. I might have to ration him back. Are you not over there doing it right now? Oh my God! Now he wants to go over there and screw around with it. Hold on. Okay. Yeah, he's you know what? Oh, now he's over rolling around in it. Here, this is what we'll do, okay? This is what we'll do. The first time I gave it to him. He doesn't like people food at all. He won't eat anything I give him or offer to him. Nothing. He's not fat. He's just getting junky. Now he's over there going wild on this stuff. I mean, never told me. What day was this? Is like, 2 weeks ago. How many days was he with me? He didn't eat for like the first 2 and didn't come up from under the bed. And he stayed under the bed for like 6 days. And he would actually come out at night when I was sleeping to eat and go to the bathroom and then go back under the bed. Hold on, that wasn't the whole thing. No, hold on. I just started it in the middle. Oh yeah, what about this? So the people downstairs from me, they had a cat before, and they had a bunch of like leftover stuff they gave me. And that's what I just gave them, catnip. I'm not all that interested in it. And they gave me some toys. And I gave them the other day. It's like this little mouse. He runs with it into the other room. Can I play the guitar? No, not really. I play the bass. That's a bass I have. This little mouse, I think it's got catnip in it. He went wild on it. You can tell how chunky he is when he gets up on his hind legs like that. If cats aren't the best, I mean, come on. Yeah, I got a laser pointer coming on the way. He's slamming it up against his litter thing. Hey, boy. Yeah, he wants to jump up on my lap right now. Come on. Come on, bud. Come on. Hey. Come on. Yeah, that was funny, huh? All right, let's keep going.
All of those things. And what the defense is obfuscating from is the overwhelming evidence that was presented to this grand jury from a multitude of sources, 42 separate witnesses, 56 exhibits, over 1,400 pages of transcripts.
Yeah, he does have some of those little fishing pole things.
The defendant, Karen Reed, killed John O'Keefe.
Oh, there he just jumped up.
They don't want you to look at that. They want you to look at who texted who when and what they said and what was asked and what was promised.
He's got catnip all over his back.
Materials provided by the U.S. Attorney's Office. A couple things that I would note is, number one, we have no idea how much of a percentage of the totality of the federal materials we have. I don't know if we have 5%, 50%, 90%. I have no idea. The other part that's confounding is that it appears that these materials are materials from the state prosecution were provided to the U.S. Attorney's Office by Mr. Yannetti or by the defendant or by defense counsel. And again, what I don't know is how much of a percentage of the total discovery from the state case was actually given and provided to the U.S. Attorney's Office in which to conduct their investigation. But it's clear
It's on my lap.
That they extensively investigated the facts and circumstances that led to Mr. O'Keefe's death. In sum, what I would submit, just as Ms. McLaughlin stated on the last date, that these materials are largely consistent with the Commonwealth's theory of the case. There is no suggestion of a third-party culprit, no suggestion of cover-up of evidence, no suggestion from the 13 civilians witnesses' testimony that we received, or transcripts of that testimony. All of them confirm that Mr. O'Keefe never entered 34 Fairview Road. All of it was absolutely no animosity between the individuals at the Waterfall Bar or at 34 Fairview residence. There was no fight, there was no dog attack, there was no eyewitness to the circumstances that led to Mr. O'Keefe's death. Witnesses also testified.
That's where he wants to be all the time, on my lap.
State grand jury in the spring of 2022, largely in the spring of 2022, and then largely in the spring of 2023 before the federal grand jury. And their testimonies are largely consistent with the defendants making declarative statements that she did it, not a question mark at the end, but clear, definitive statements on scene, that she had discussed the damage to her taillight prior to leaving Mr. O'Keefe's home on the morning of January 29th. You have a number of different statements that were alluded to by Mr. Jackson in regard to text between from Trooper Proctor's phone.
He'll be asleep in about 30
Text
seconds.
messages between Trooper Proctor's phone and Julie Albert's phone, except for two no-content text messages, one from June 21st, 2020, and one from September 1st of 2020. There is a discussion between Trooper Proctor and his sister because Julie Albert had provided child
He's
care
hands down the sweetest cat I have ever
for Trooper Proctor's
seen.
sister. Trooper Proctor also testified that Julie Albert never did that for him, never watched his kids, never had looked after his
He
children.
just wants to
That
be
essentially never
with
happened.
you, on you, against you.
Lastly, get to the Google search, and I would agree with counsel in the sense that it's really no longer open for debate, but I'm not really sure why we're still even talking about this or why this is still a topic that they're pushing. Essentially, what we have is, yes, what counsel mentions is there is one expert who was given two extractions, presumably provided by defense counsel, that indicates from that particular FBI expert that the searches were done at 2-something in the morning. What counsel neglects to sort of raise
He's a
and
wicked
report is that there's a
snuggler.
separate, and I forget exactly what it stands for, but an RCFL analysis of the phone, in which through both Axiom and through Celebrite, and that conclusion of that expert is that the searches occurred when Ms. McCabe testified they occurred.
Good night, Ruth. Thank
After they
you.
conduct those searches at 6:23 and 6:24.
Wow, it's so late.
Really, the argument stops at the point of it's not, we didn't do our job to get the Cellbrite version that shows that information did not exist at the time.
I didn't cover nearly what I kind of wanted to, but
run something through a Cellbrite version that isn't in existence at the time the grand jury is conducted. It's a subsequent version in which their expert, Mr. Green,
I like to be complete about things. Like Lana's like saying all this shit. I want to make sure we have a backdrop of what she's saying. I don't want to guess about anything. She's a provable liar every time. And I want to make sure, like,
these purported search without looking at the cache files, without looking at the DB list, without looking at the SQLite database, without looking at the wall file, all of which was done not only by Trooper Garino, an independent expert named Jessica Hyde, which counsel has all of it, as well as the senior technical analyst from Cellbite itself, a man named Mr. Whiffen. Counsel's had this report for months at this point. And essentially, Mr. Whiffen is essentially the person who creates the software that all of these experts are using. And his definitive opinion indicated in his report is that Ms. McCabe conducted those searches at 6:23 and 6:24 in the morning. So I would agree with counsel that it's really no longer up for debate. I think we just disagree.
Larry, a good one.
The totality of the evidence, and what I would submit as the overwhelming evidence that was presented to this grand jury, all of these sort of individual parsing of stated malfeasance simply doesn't even come close to sustaining the burden under Odell. And for that reason, I would ask that the court deny the motion to dismiss.
Okay. Do you want a few minutes, Mr. Jackson, to respond?
Very briefly.
Okay.
First of all, it's always interesting to hear an argument that suggests there's nothing to say.
Oh, look at that 5150 out in the front row.
You said, look the other way, look the other way. Oh, it's the defense that wants you to look
Is
the other
that
way.
her?
We don't want you to look the
No,
other way.
it's not her. I'm sorry.
You look directly at the evidence of the compromised relationships that Trooper Proctor had and hid. That's what we want the court to look at. He suggests, oh, well, there's just a couple of text messages. It's no big deal. The fact is, Your Honor, she really hit him. She really hit him with the car. Let's remember, she really hit him. And these text messages, they mean nothing. We're talking about the integrity of a sitting grand jury and the presentation before that grand jury. What Mr. Lally now has in his possession, but he didn't mention, now that he says, oh, well, she killed him. Let's just get on with it. She killed him. He's already tried and convicted her in his mind and tried to do it in this courtroom. Doesn't quite work that way. Now Mr. Lally has in his possession another thing from the feds that we didn't have access to. The federal investigators hired, independent of us, we had no idea, and independent of the Commonwealth, hired a professional reconstructionist, 3 PhDs.
Yeah, we're probably going to shut it down at 3:30. It's getting ridiculously late. But I am going to pick up on the rest of this tomorrow. I'm not going to wait like 2 days or anything. We're going to pick up on this tomorrow. We're going to listen to this for a bit, and then we're going to highlight the absolute craziness that Lana has been spewing lately.
To look into exactly this issue. Did Karen Reed's car, did her SUV make contact with John O'Keefe? And their conclusion to a person was...
Yeah, Olivia. Hey, how you doing? Nice to see you.
The damage on the car was inconsistent with having made contact with John O'Keefe's body. In other words, the car didn't hit John
Lally
O'Keefe,
was
and he wasn't
more
hit by the car.
effective.
Period. Full stop. That's their...
It's just the
and
truth.
Expert, not ours. Not somebody on our payroll like Mr. Whiffen or one of their experts or Trooper Guarino, who's an arm of the agency. This is an independent federal government witness or series of witnesses who say unequivocally that car did not hit John O'Keefe and John O'Keefe was not hit by that car.
Yeah, and that ended up being absolutely correct. Yeah, the thing about Brennan is he really couldn't hide his defensive style, right? He just came off as such a scumbag and just, Lally's like a typical douchey prosecutor. It's like the role reversal is very strange.
But he didn't mention that. Second, he argued that the texts were not, these aren't texts between Julie Albert and Michael Proctor. These are texts between his family members. And then he mentions these two texts that had no content. What are the chances that Michael Proctor sent Julie Albert texts with no content? Your Honor, it's not that they didn't have content, it's that it couldn't be recovered, which sometimes happens. But we do have evidence that they were in fact in communication with each other as early as 2020. And with regard to the 2:27 a.m. search, it's not a three-card Monty. It's not a shell game or whatever other fanciful thing Mr. Lally wants to suggest that it is, as he tap dances his way around this. He says that our expert, Rick Green, didn't look at the SQ Lite database. Yeah, Mr. Lally, reread his report. Yes, he did. He didn't look at the wall file. Yeah, Mr. Lally, reread his report. Yes, he in fact did. And he's the one that found the 2:27 a.m. search. And with regard to the Regional Computer Forensics Lab, that's the definition he couldn't remember. What they actually said.
I can never get over the look on
what they actually said was, yes,
Liza Little's face. It's like she just can't believe what the hell is going on. I think that's just her look.
In the phone, Jennifer McCabe's phone, and it's not up for debate. That wasn't presented to the grand jury. The information that we've been talking about today wasn't presented to the grand jury. We're talking about the integrity of the proceeding. He doesn't get to convict my client by standing up here and pounding the table and saying, oh, she did it, she hit him. So let's just all get on with it. Deny this motion. We're talking about the integrity of what is the foundation of Massachusetts judicial system.
Oh, thanks,
and that
John.
integrity was compromised. That integrity was impaired. And it demands that justice be done. And that justice is in the hands of this court. We ask this court to do what the evidence dictates, do what the law dictates, and that is dismiss this indictment. That is the only way justice will be found in this case. Thank you.
All right. Thank you very much. Ms. Giannetti, are you all set?
Yes, Your Honor, thank you.
So the same time, and let's see how you do with it.
Let's see how you do with it.
We believe our witnesses. They are telling the truth.
Poor Aaron.
Karen Reed is guilty. Any suggestion to the contrary is a desperate attempt to reassign guilt. Can you imagine a district attorney with a sworn duty to do justice and respect the presumption of innocence issuing such a statement in a pending case? Before August,
Yeah, Allie, I don't just want to,
yet that was the message of
rely on my memory or anything. I want
to potential jurors in this case on that date. I've been practicing criminal law as both
to absolutely know what I'm talking about.
For over 30 years now. Never have I seen such unethical conduct from a prosecutor. I know of at least one law professor who used Mr. Morrissey's statement in his class to teach his law students how a prosecutor should not act.
Should not.
Another member of the bar has already reported Mr. Morrissey's.
Yannetti's just a murderer, man.
We are here with a motion to
just gets up there and slays.
From further prosecuting this case because he has a personal interest in the outcome. Your Honor, this court should grant our motion to disqualify. And at the outset, I note that we've also moved for sanctions, dismissal of these indictments as a result of his misconduct. But we have so many additional grounds for dismissal as a result of the material provided to both sides by the federal authorities that we will be filing a further motion to dismiss for extraordinary governmental misconduct. My co-counsel has spoken to that previously. To the extent that the court entertains our motion for sanctions, specifically dismissal, as a result of his
So
egregious.
can I just interrupt there and ask you,
Ah,
are these
Jesus.
going to be the same motion essentially?
No. There's information and evidence that's been provided by the federal authorities which deals with the egregious conduct of both the district attorney and his investigators and the police. That will be the subject of a separate motion, Your Honor.
So I thought that was going to be your supplemental memo to this motion. It sounds like it's the same issue, Mr.
No,
Kennedy.
it's not. And
It's not, bitch. And Olivia, maybe I can ask you, because you would know. So what Lana was claiming while we're watching these pretrial videos, she claimed that before the gag order was denied to the prosecution in trial one, she says that the defense, Yannetti and Jackson, straight up lied, said they had gotten the federal that they had learned about the federal investigation from Turtle Boy and put a Turtle Boy article in the motion, and that was their way to avoid the gag order so they can continue running with their false narrative. That's what she's saying. That's what she said earlier today. Nothing like that ever happened. I don't know what she's talking about. Maybe you can speak to it. I don't know.
Saying to the court is, I have limited time.
When I interrupt you, I stop the time.
Well, I appreciate that, but even with that, Your Honor, the focus of my argument is going to be on the disqualification as opposed to the dismissal. I've submitted papers on the dismissal. I will rest on those papers with regard to that issue. That's my only point.
All right. So when you file the other motion, I need you to include in your memo how that's different specifically from this. Not just the remedy, but how the basis of it is different.
Understood.
All right. So I'm going to start you again from scratch. Go right ahead.
I appreciate it. Well, Your Honor, this case admittedly has been an unusual one for a district attorney to deal with. The district attorney's office is not accustomed to a criminal defendant fighting back in the way we have prior to trial. What usually happens when the prosecution brings charges is they detail the allegations at an arraignment in court, and as a result, their narrative and theory of the case becomes widely reported, while the defendant and the defense team remain relatively quiet. After arraignment, moreover, the media typically lose interest and wait until a trial or potential resolution of the case before they start reporting on the case again. And in this way, the district attorney's office is quite accustomed to always controlling the narrative in pending cases, at least until the defense makes an opening statement at trial. And as long as the prosecution gets to control the narrative in the press, they have no problem with what's being reported. But of course, this case has been different. Their control of the narrative did not last very long here. In our view, it became clear very early on in this case that their narrative was wrong. Their theory of the case was wrong. Their allegations did not fit with the evidence that we fought so
Yep.
hard.
Night. Thanks for coming. We're going to be shutting it down soon.
Years. So along the way, we spoke out about our findings of exculpatory evidence, mostly with.
All right. So what we're going to do here, I'm going to, just for a couple minutes before we shut it down, come on, Lana.
The defense team felt that it was very, 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 very important that Karen Reed's reputation in that area, to the point that you're going to lie, because you would have beat this. Because I have to ask you guys, it wouldn't have changed. What's going to change with what we saw in the case? What happened beforehand? Okay, there's a couple things here.
Yeah, I'll do the
Generate
rest
money
tomorrow.
to be able to pay for stuff, right? This stuff is going to cost you a lot of money. How are you going to fucking be able to afford all this? We have to figure out a fucking way, okay? But if what we all sat back there and we just
But
watched was
this chick's whole
what
live
did
today was
talking about a
absolutely
federal
fucking wild.
investigation truly
as you're
do.
saying.
It intimidated people. You don't think that's intimidating?
Fucking piece
It
of
made
shit.
people worry. It influenced people. The potentiality of that.
Not so much free Karen Reed anymore, honey.
And that's why, Bernie, with my disclosure that I make, is that Karen Reed will always get my nod because your life is on the line. Of course, you're going to do anything and everything that the fuck that you can. Okay?
But she's saying she lied
But
and she cheated.
It's a sad day when you have the best defense attorneys, like literally the best, they say, right? And that you felt that you needed to go about it the way that you did versus y'all can fucking smash to smithereens this entire case, okay, to the point that the evidence is the evidence. So why fucking do all
Oh, she's no fence sitter. Oh, no.
scratch? That's why. This is what gets people. Why don't you go and read the fucking rules? This is what gets people to lose their fucking practicing license.
Yeah, but it's okay for prosecutors to do what they did. She has no problem with that.
Lie when you could have stipulated and just said, fine, we're going to be gagged because the fucking oil machine just had started. It hadn't even gotten anywhere. We still got to do all this stuff. We have to fight against this gag order because we need more time. We need more time to be able to do what the fuck we need to do. We can't get gagged right now.
Why does she?
Why? Because we're the source to Turtle Boy. We're the source to Turtle Boy.
The gag wasn't really that fucking important. Like, what do you think? It's everything to a case? Her position now is Jackson and Yannetti and Karen Reed all lied straight up, intentionally lied to the court to avoid a gag order. That's what she's saying.
Why would you lie? Why would you risk your entire fucking career? Because nothing happens to you. Because nothing happens to these lawyers, right? Who cares? We can just lie. Doesn't matter. Doesn't matter. Well, they can answer that question, and I demand, not demand, but like ask these questions. Say, you want to know why anybody would ever put themselves in this situation because you would not. But if you want to get paid, and you got a guy telling you, and you're sitting there meeting with him and talking to him on the phone, and what he's telling you, like, dude, I raise money left and right. You know how much money I've raised doing X, Y, and Z, and how I do it is I outrage the community. Outrage is how you get people to feel.
No, like your fundraiser for Chris Watts, you pile of fucking dog shit.
What was the difference between why Karen Reed was?
She's talking about the first gag order in the first trial, the one
Then she was acquitted. But
that was denied.
I don't know. You guys tell me.
To the prosecution. She didn't gag the defense in the first trial.
But if you think
she did in the second trial.
Karen Reed, Alan Jackson, and David Yannetti are going to get in the fucking bed with Aiden Carney again, you're out of your fucking mind. Aiden Carney.
They don't
has done
have
everything
to.
Possible to take them down with him. You guys aren't getting away with
Such a
this.
fucking
That's what
idiot.
he's saying. You guys aren't getting away with this. I'm going to come out. He knows what he's fucking doing. He knew what he did when he said what he said, which was Alan Jackson. They're just geniuses. Oh, it was great. Alan Jackson just said, yeah, hey, we got it from him. They gave me the information. I read up the blog.
She's
and they
wrong.
used me as
She's
the source.
wrong.
God, you're so genius. That's what the fuck he said. They didn't have any of that until just recently. That just puts the icing on the cake, right? But even before all of even that, how did Karen Reed get her devices seized? Because of this. Because of the timeline that I just described. That's how. Because it was enough to at least seize the data, take it, to preserve it. Because we need to seize it so that we can preserve it. Because, and now let me build up more.
How else would you get the? Oh my God, she's so stupid.
Turtle Boy's a sick fuck.
I mean,
So you think that you're ever going to go in fucking bed with that guy again?
this thing is talking about a sick fuck.
To bring you down because he's not going alone. He's not going to prison alone. Aiden Carney is going to be a convicted felon. Whether he serves time, whether he doesn't serve time. But I think we should all ask ourselves, why in the fuck would you ever risk your career as an attorney over a gag order?
He didn't.
To make sure that there's no gag order
You
at that point in
idiot.
time. Because you lied. You lied.
You
So that you
idiot.
could make it so that the gag order would not be in place for what? What ended up happening in June, July, August, September? What was going on?
She's so fucking stupid.
Well, that's when Aiden
Or she's just a liar and a grifter.
Carney turned it the fuck up. That is how you oral argue your position in front of a jury for them to truly understand that this was reckless disregard for the truth, that there was a plan in place, and that they didn't have enough time yet to get it all where it needed to be, and that's why they fought against the gag so hard. Don't sit here and tell me that I don't know how to oral argue a position, because I do. You don't need to be an attorney to do that. If you want to be a good attorney, yeah, it really helps. But right here, right now, what I just explained is the most important piece.
See you, Hunter.
To show to a jury and to show the lengths that they went through to make sure that first attempt at a gag order was not successful because the work wasn't done yet. That's how you show a partnership. Why would they lie?
Almost made it, Hunter.
Because they weren't done. Absolutely, I don't care. Nothing that I'm talking about changes the fact that I believe that the Canton Police Department
Almost got that hard R in there, didn't you?
nothing changes
Not
the
quite.
fact that how it looks is that Karen Reed and her defense team wanted to keep it hella under wraps, that Karen Reed and a Hilly boy, Brian Higgins, had a thing going on.
She had 900 people watching today. 900.
And if you think about it, how ironic that if the gag order would have been successful,
I struggled to get 200, but this bitch comes on here and lies her head
Isn't that
off
ironic?
and
Don't
gets
you think?
900 people.
Them's the facts right there. No shit, they're not for fucking journalists.
Yeah, I guess it does.
Who do you think was writing every fucking story? Can't sit here and help them.
Can't sit there and help them. Like, thinking she's
If you
just
guys
like,
say that you fight against
oh
corruption
my God.
and you don't see how you cannot be corrupt to fight it, then you aren't fighting against corruption. Because the people that are defense attorneys one day, they become what? District attorneys one day, they become what? Judges one day. Same thing with prosecutors. They become what? District attorneys one day, they become judges one day.
So what?
What the
What's your
fuck's wrong with you
point?
guys? Wake the fuck up.
Wake the fuck up.
Integrity. Integrity.
Integrity.
And no lawyer is going to talk about this because they have a code just like the goddamn fucking cops have codes. You're not going to go around throwing attorneys under the bus.
The fake
Just like,
outrage is
hey,
fucking...
the thin blue line, blah, blah, blah. I don't want to hear that anymore out of Alan Jackson's fucking mouth. You want to know why? Because y'all have a code. That's being hypocritical.
Wait, hold on. Is this the same person over here? Is this the same?
It's Friday night. I'm
Not
just getting ready
her?
for my Tender date.
She's
me and Chris
outraged?
decided that we're gonna do this whole open marriage thing.
Why should we
I got a
care?
new lifestyle membership, and I'm just really excited to explore it. I think a little bit, but with it being such like a long week with the election. Hey Sharon, oh my God. Hey, I know somebody reported the cream of some young guy. I can't even believe it. It must have been that shitty of a guy. Like who would
He's
ever report the cream of
outraged.
some young guy? Anyways, guys, I just it's been a long week, like
Oh, we
I said.
should be
I'm just gonna let loose.
so
I think I'm
worried.
gonna adopt a child. I just got so many amazing ideas for 2021. I'm just really looking forward to, reinventing myself, getting out of my comfort.
Fucking pig.
This is black and fucking white. They lied. They lied in 2023 to keep a gag order off their fucking backs so that they could still finish what they planned. Why the fuck do you need to put out Sarah Levinson's nursing license? Explain that to me. You don't. You do not need to do that. Why did you need to do that? Hey, don't talk about Julie Nagel. Don't mention that report. Why?
Why? Yeah, exactly. Why?
All right, then I'm going to go ham on Sarah Levinson. The day that I would have ever gone to
She's in the tank for everybody else, but Karen Reed, the defense, and Turtle Boy. I mean, it's clear, is it
I
not?
thought that I could go to people's houses in Aliquippa and start chanting that these black women and these black
And she brings up this racial
case,
thing, and I don't know
when
what the
Turtle Boy
fuck
that gave
she's
the information,
talking
so
about.
you're still then the signal comes out. But then Turtle Boy's just like, fuck this dude. Ready? Hey guys, Alan Jackson's a genius in the defense. This is how this went down.
She keeps bringing that up. The Alan Jackson is a genius quote. Why is she hung up on that? That's fucking weird. Why would that matter to anything whatsoever? What the fuck is she talking about?
They used me, gave me the information, then I put it out there in the blog, and then they used the blog as how they got the information. Isn't that just awesome? That's how fucking great Alan Jackson is? You think Alan Jackson's gonna talk to that man again? Well, if he does, fuck, then Turtle Boy has way more on Alan Jackson than we could ever imagine. Because if I was Alan Jackson,
what an
I'd be serving him
idiot,
some
man.
cold ass fucking karma served and some cold ass subs down the road.
Yeah, really? Well, too bad you're not in a
That's
position
cool,
to
man.
do that.
Because Alan Jackson, your boy Turtle Boy, literally just tried to get you disbarred.
Wait, you just called Alan Jackson a
The
liar.
whole goddamn defense team. Because Yanetti's the one coming out here, and my brother counsel over here, Alan Jackson, he wasn't doing that. He was speaking about the fact because he got it from the media.
She's a fucking retard.
What's up, Karen? Black hat all over the place.
What a
A
fucking
judge
idiot.
has denied a gag order request for the Karen Reed murder case. Now, she is the woman charged in the death of her boyfriend, who was a Boston police officer. Reed is accused of killing John O'Keefe last January.
She's hanging
Nana
everything
and
on this fucking gag order, dude.
Will not drop. The trial still set to begin 3 weeks from today.
Lana speaks the truth. Look at these retards she has in here.
Will prevail. William Reed will get the chance to test his theory after an attempt to get
Lana's
the case against his daughter dismissed.
a
failed.
truth
I want this to
seeker.
end. And if it has to end through the court proceeding, then it will. This afternoon, Judge Beverly Cannoni denied a defense motion to have the murder charge against Karen Reed dismissed. The judge still hasn't ruled on
Yeah, we got it. What do you
No,
got?
you don't have to believe Aiden. I just gave you the timeline.
Just give us a timeline, everybody. Forget it.
Okay.
I mean, case
That's how
closed.
Karen Reed's cell phone was seized. Okay. And in a civil case, it is not beyond a reasonable doubt. Okay. Like it is in a criminal case.
Yeah, we know that, you fucking idiot.
It's like, I mean, it's undeniable. The lie. Because it was never Aiden Carney. He's going to be asked that. It's a civil case. Aiden, did you provide the defense with the information of a federal investigation? Yes or no?
And that would come up in his defamation case. Why? Why?
No. So your blog, the blog that you wrote,
Oh, you think it's going to come up in his
You weren't your
criminal?
own
Why would it
source.
come up in his criminal case? Like, I don't.
isn't it true, Aiden, that you received that information from the defense team? I'd like to plead the fifth. I don't think that's a fifth question, but
I don't think that's a
setting-
fifth question. Did you hear it just say that? I missed that earlier. I don't think that's a fifth question. Like there's some questions you couldn't take the fifth on if you wanted to. Not that that question would ever come up, and not like you would have to take the fifth. But imagine sitting there saying you know everything about the law and saying, I don't actually think that's a fifth worthy question. What do you think? There's a list of questions you can take the fifth
I'm
for,
saying
you
my
fucking
journalistic privileges-
idiot?
Oh, are you? I don't think those are.
Oh my
necessary.
God, she's
I
so
don't think we had
fucking
those in
stupid.
Massachusetts. Okay. It's preponderance of the evidence, guys, and the evidence by that standard is 1,000% met, and it goes, whoop, it's there.
Yeah, and you're right about everything, Lana.
People that are
You're
supporters of the defendant.
you're
And then
1 in
also-
15 in your own cases. I mean, forget about all these other cases you're wrong about.
A significant contingent of people that believe that law enforcement got it right.
She's so sure of it,
Killing her
though.
boyfriend, Boston police officer John O'Keefe.
Okay, I'm going to end us with this thought. Okay,
Well, you're not going to end it because there's still like 30-something minutes left. So,
John O'Keefe gets out of the car.
oh
Okay?
God, here we go.
Which I believe happened, right? I just don't believe that it was initially at 34 Fairview. But let's go ahead and go with everybody else's. It was at 34 Fairview. Okay, that's where he initially got out of the car. The steps and the data showed that it was before then, but whatever. Go ahead, go with that he initially got out of the car at 34 Fairview. And the defense did not argue against this Google search that everything that had happened with the glitch and that it actually was made at 6:23, whatever the fuck time was, not 2:27. They never put up an argument.
Like these people in her chat are maybe the dumbest people that are
Here's
on the
my
planet.
question. Pocket state. Okay? Pocket state. If you need to take the phone and place it in a Faraday bag, after the phone was placed into John O'Keefe's, let's say his right pocket, his left, his back, doesn't matter. It's in a pocket. Okay?
That's not what pocket state means.
John O'Keefe's phone, it clicked off on the side and then it went to pocket state. Right?
It's not what pocket state means.
How do you get the phone into a Faraday bag without it coming out of pocket state?
That's not what pocket state means. It's a term. Meaning the camera is blocked somehow. It doesn't mean it's in a fucking pocket, but they call it pocket state. Oh my God. Oh my God. I don't know. I'm almost done. I didn't know there was an audio problem. I can do that.
I've been thinking about this question since the trial because this was the first trial that I've ever been a part of and covered where pocket state, okay, has been a thing. So
It's a
I want you to hear this
idiot.
out. Now,
oh my God, here she goes.
So what this means is in order for John O'Keefe, he walks up and I believe there's a potentiality that he went into, let's say, the side of the garage door, and actually in there was Chloe. And then so when John actually just goes right into the garage from that side door, not into the house, either one of those doors, goes in and he's immediately, the dog was in there and spooked the dog. And so the dog jumps up, John goes down, hits his head, he's out. Okay. And then they don't find John until they go to get the dog out of the garage. Okay. Which then
She just got done saying she doesn't believe anything Karen Reed said. Why is she now?
if you're going to try to move John and carry him and place him on the lawn, you're going to have steps when you're carrying him if his phone is in his pocket. Okay. You're going
Not if you're fucking carrying him, you fucking loser. What is he doing? Walking in his incapacitated state? How do you think steps would? Oh my God.
going to register steps. There's no way around that.
There's no way around it.
But it's going to keep it in a pocket state, but you're going to get the steps. Okay. You're going to register walking steps. Okay.
Oh my God.
So I said, okay, so that to me, I was like, okay, that couldn't have happened. Then I said, okay,
we have one of the greatest legal minds at work here, people. Let her cook.
what if the lights are off in the garage, so it's dark? Okay.
Yeah, right, right.
And is it possible that has anyone tested it that it has to be so much light to consider it out of pocket state. Like how much light has to be on that phone? Okay. That is there a way that
The camera has to be unblocked. It's not about.
you'd have to like test it to be able to say if the light was off and that you were if you transferred a phone to a Faraday bag in the garage with the light off, would it stay in pocket state? Okay.
You're a fucking pocket state.
I'm a person that likes to look at the evidence.
No, shut the
right?
fuck up.
And I'm really curious. I don't want to talk about any of the wounds. I want to talk about the phone. Because in so many cases, people's phones.
Okay, we're gonna end it there, people. I can't continue any longer tonight. Yeah, we're gonna call it there, but we're gonna finish it tomorrow. Not sure what time tomorrow, but we're gonna finish it tomorrow. I can't. I've been listening to this lunatic, in preparation for the show. I just can't do it no more. So did we do these yet? Officer Twa Katie, $20. Alien, Texas. Yeah, we did these. Yeah, thank you all so much. I appreciate you all so very much. Had a good night. I didn't have a ton of technical breakdowns. Of course, the iPad, $1,200 setup did not work again. I'm gonna have to figure that out. But other than that, we had some Brando stuff, and we listened to a lunatic, Lanatic, if you will. Yeah, I'm going to. Yeah, it's 4 minutes of 4, everybody. I'm in a pocket state myself. So everybody have a great night. And we're going to finish this tomorrow. And I will make the live a couple hours ahead of time so you guys know. Anyways, thank you all for being here. The likes are 170 something, and it's pretty good, given what we've had here. If you haven't hit the like, please hit it on your way out. And yeah, thank you very much for being here. I appreciate you all very much. Okay, cool. Have a good night.
Yeah. Just Andrew Timmons. Yo. I'm the man in charge, triple dip justice, my reach is large, indicting T-Rex arms, yeah they on display, short reach, big mess on a public way, yo. Adjust your antennas, tune in tight, Posse rules the bench, I'm the law tonight, be so high, they touch the sky, the joke ain't over, just watch me fly, yeah. Adjust your antennas, tune in tight, Posse rules the bench, I'm the law tonight, be so high, they touch the sky, the joke ain't over, just watch me fly, yeah. Advanced years, wisdom stacked, try me once, no turning back, James Jackson ordered, case dismissed, Kasi cheek strikes, you won't resist, yo, yo. Order in the court, the rhythm pounds, justice echoes, breaking bounds, prosecutor by day, mic in hand by night, adjust your antennas, I'm the signal, alright. Antennas, tune in tight, Kasi rules the bench, I'm the law tonight, be so high, they touch the sky, the joke ain't over, just watch me fly, yeah, adjust your antennas, tune in tight, Kasi rules the bench.
The issue.
Right, basically, they oaths across the board. The messages say, police take an oath, lawyers take an oath.
Their conscience, but I also have seen how much the speaker their conscience, but I also have seen how much the speaker and Senate President can wield according to their conscience, but I also have seen how much the Speaker and Senate President can wield